Please, Your Lord. My Lord, in presence of the petitioner as well as the caveator, I beg to mention item 3. My Lord, in this case, Lordship directed me to obtain the instruction with regard to the outcome of the appeal. My Lord, I am told the appeal is again fixed for hearing on 17th as the parties failed to produce the relevant documents. So may I pray, my Lord, that the matter may be listed either on 21st or 22nd, my Lord.
Yes, who is for the other side?
I am for the petition.
No objection. Mr. S.K. Talukdar, Learned
Yes, sir.
Standing Council Cooperation Department, Assam submits that although the hearing before the registered cooperative societies was originally fixed on 8/8/2023, yet on that day, hearing did not take place since the parties failed to appear. Now the hearing has been fixed on
17th, my Lord.
17th of August 2023. Therefore, the Learned Departmental Council has paid for posting this matter again on 22nd of August 2023. Since the prayer is not opposed, same stands allowed. List the matter accordingly.
The caveator is also present.
Yes.
Oblige me.
Your Lordship, in item 38, which is listed today.
Hmm.
Your Lordship, the other side has filed an affidavit in opposition.
Hmm.
That may be brought on record because that is necessary.
What is this matter about?
This is matter relating to the police inaction.
Police?
Inaction. And this is very serious.
Yes, but why these cases are listed on the bench, which is not supposed to take these matters? Huh? These are bench four matters. Why does you call the register, please? Yes, I will get it.
May I please, Lord? With the
Yes.
consent of the petition, I beg to miss item number 24, my Lord. That will be taken after 3 weeks, my Lord.
You are appearing for whom?
Oh, I am here for the GMC, Lord.
On the request of Mr. S. Bora, Learned Standing Council GMC, made with the consent of the other side. Admission hearing of these matters stands adjourned for 4 weeks. List accordingly.
Oblige.
May I please, Lordship. Lordship, with due consent from the other side, I beg to mention item number 26, Lordship. So in this case, Mr. K.N. Chaudhary is leading Lordship, he is out of station today. So-
Prayer for adjournment of admission hearing has been made in this case on the ground that the senior counsel engaged by the petitioner is not available. Since the prayer is not opposed, same stands allowed. List the matter again after 4 weeks. Yes.
Lordship. But I have another request, Lordship. One matter I want to listing Lordship for withdrawal, Lordship. Let it on 11th, Lordship, 5.
Yes.
May I please, your Lordship? Lordship, I beg to mention item number 30. I have taken the concern of the other side, Lordship.
Item number?
30, Lordship.
Yes.
Lordship, in this matter, we have yet to be filed affidavit in opposition. We have received the instruction, Lordship. We will file, Lordship, may kindly grant 2 weeks time.
The Learned Standing Council, Guwahati High Court 6. Further 2 weeks' time in this matter to file affidavit. Since the prayer is made with the consent of the other side, same stands allowed. List the case accordingly.
Oblige, Lordship.
May I please, your Lordship? My Lord, I beg to mention item number 35. So the government in this case has filed the affidavit in opposition and it has been submitted on Monday. my Lord. So I need some time, to reply this evening.
How much time?
2 weeks time.
On the prayer of Learned Council for the petitioner, made with the consent of the other side. This matter stands adjourned for 2 weeks shows to enable the petitioners to file redundant affidavit.
I have another prayer, my Lord, for
This is
listing-
item 35.
35.
Yes.
For listing, my Lord, I have another 2 petitions, my Lord.
Ah.
So I have to take steps, my Lord. Twice, my Lord, I have taken steps, but the service is not complete. So I may be allowed to, I may be required to take the service by Dasti, my Lord. So,
But that cannot be done unless the matter is listed.
yes, that is why I'm praying for this.
Next week, next week.
Lordship, I'd beg to mention item number 21 of the daily list.
Hmm.
With the consent of the other side, your Lordship may kindly pass over the matter for today. There has been a medical emergency in the family of the main arguing counsel, Ms. M.
Therefore-
Bhattacharjee. For the petitioner, your Lordship.
As paid for by Ms. P. Dasgupta, Learned Counsel for the petitioner. With the consent of the opposite party, this matter stands passed over for the day. Yes.
May I please? May I
Pleasure.
please pray for listing of a matter tomorrow, my Lord, in the motion column.
Hmm.
It's a little urgent, my Lord.
What is the matter?
It is regarding a judicial grade 3, my Lord, written examination whereby I was one of the candidate, my Lord. I'm a blind candidate,
Hmm.
but my candidature has been rejected just because I did not fall in the general category, my Lord.
But why are you mentioning before this bench?
My Lord,
We have not checked the cause list.
my Lord, I was,
Huh?
I'll go and mention before the appropriate.
Yes.
I'm very sorry, my Lord.
Yes.
Very sorry.
May I please, your Lordship? Lordship, I beg to mention for listing an unlisted matter.
Hmm.
In this matter, government has filed affidavit and we have filed our reply also. So pleading is completed. So may the matter
You make
become
an application before the registered bench. Go and make an application.
Please, your lordship, in item number 8, we have filed an affidavit in opposition yesterday. The
Hmm.
same may be called for.
Yes,
Obliged, your lordship.
May I plead the lordship, I beg to mention for listing, my lord. The matter was filed on 4/8/2023. The matter related to holding of election of cooperative society.
you are to listing for motion.
Yes, my lord.
When?
But 12,
12th is a Saturday, I believe.
11, my lord.
All right.
Thank you, my lord.
May I please lordship, item number 43, your lordship, the engaged advocate. Item number 43, lordship, the engaged advocate, Mr. N.N. Kamakar was expired, your lordship. So matter may be adjourned. 43, lordship.
Mr. N. Karmapakar is expired.
Yeah, expired also.
On the prayer made on behalf of the petitioner, this matter stands adjourned for 2 weeks on the ground that the counsel for the applicant stroke petitioner has expired. Register to list the matter accordingly.
Good day, lordship.
Yes. Point of third, assessing unity 38, the police section. Mechanically present থাকে একটু না হয় এটা sort of বলে কিছু প্রবলেম থাকে urgency of police action. Yes,
Miss Police Lordship, first I beg to mention for listing on WBC, my lord. Can it may be listed on 8/11/2020, that is on Friday, my lord.
what listing for what?
For allotment of land, my lord. That is,
No, read petition should be listed for what?
it's an urgent matter, my lord, for.
All right, rejected. Next call, please.
Okay.
You don't even know it has to be listed for what? Call.
Excuse me, sorry, for admission, my lord.
Admission, you request the registry first. Then we'll-
Thank you very much.
May I please your lordship?
Hmm.
Lordship, this is the petitioner is a landlord. So his 18 lesser land were acquired under the National Highway Act. So my lord, this 18 lesser land is a park zone. This is a park, it was a parking, my lord. And behind this, that very plot of land, the petitioner had a hospital, private hospital. And this building was constructed amounting rupees for more than 44 lakh at that time. And his establishment will be
So
affected, my lord.
What is that you want? What is the relief you are?
Reassessment, my lord.
Huh?
Reassessment,
Reassessment for compensation.
for compensation.
Well, we'll issue notice then. You are Mr.
ATM Hussain.
or Mr. ATM Hussain Lara counsel appearing for the writ petitioner. The petitioner has approached this court by filing the instant writ petition seeking reassessment of the valuation of the land measuring 18 acres acquired by the authorities for construction of 4-lane highway on the ground that no proper assessment of the land has been carried out by the authorities till date. Full stop. Mr. S. Borua, learned Government Advocate Assam, submits that some time be granted to obtain instruction in the matter. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Borua has appeared and accepted notice for respond numbers 1, 3,
1, 3, 4, 5, and 6.
1, 3, 4, 5, and 6. Okay, then report Mr. R.K. Dev Chaudhary, learned. You have 4?
7.
Acha, Mr. R.K. D. Chaudhary, learned DSJ for respond number 7, and Ms. G. Hazarika, learned Standing Council Revenue Department Assam for respond numbers. Respond number 2. No formal notice is required to be sent to the same respondents. Who is for 8? Extra copy of the rate petition be furnished to the learned Standing Council so as to enable them to.
There is
Huh? There is a Standing Council.
8 is implemented as respondent.
General Manager, NHI DCL.
Manager standing council.
A copy of the writ petition along with
Similar
written up
development.
notice be served upon Standing Council NHI DCL on behalf of respond number 8. This matter be listed again by reflecting the name of learned SC NHI DCL.
There is an interim prayer, my lord,
What is the interim prayer?
for part payment, my lord, if this is.
Heard on the prayer of interim relief, the said prayer stands rejected. Compensation, what interim prayer?
As per the order dated 10/7/23, the matter pertains to the Itanagar bench. It has been transmitted from this bench. The matter pertains to the non-payment of adequate compensation. So may I pray let notice to be issued
Adequate compensation for what?
for acquisition of land also. Because where the landowner of the
The writ petitioners have approached this court by filing the instant petition alleging non-payment of adequate compensation for acquiring the land belonging to them by the authorities. Must have heard Mr. D. Chatri, learned counsel, appearing for the petitioners, peruse the amendments made in the writ petition, NOM 8 weeks. Who is appearing for whom?
I am appearing for one, lordship.
Mr. R.K. D. Chaudhary, learned DSGI, has appeared and accepted notice for respond number 1. Mr. Arun Chandra, learned senior government advocate AP for respond numbers 2 and 5. And Mr. Who is the standing counsel?
There
here?
is no issuing council.
2 and 5, no formal notice is required to be sent to said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the learned department council within a week from today, so as to enable them to obtain instruction and file affidavit. Petitioners to take steps for service of notice upon respond numbers 3 and 4 by registered post with AD within a week from today.
Period of 1 week.
Yes.
Yes. Oh, yeah. Observe this.
Please, your lordship. Lordship, this is matter relating to the levy of GST on Electricity Regulatory Commission, lordship. This is a body, it is constituted under the statute, Indian Electricity Act 2003. If I may take your lordship to section 82 of the Indian Electricity Act 2003, lordship.
Item number 5 and 6, lordship. I am appearing for the respondent. We have almost prepared the affidavit, lordship. By Monday, I am able to file it.
Item numbers,
5 and 6.
you're appearing for the GST authority
Yes.
and
I'm appearing on 4, your lordship.
for the GST authorities. So you're also filing affidavit.
Yes, sir.
Then you bring the affidavit on record, we'll post it.
Lordship, the similar order in the other two matters in 4, 5 and 6, there is a similar order. Lordship, that same interim may be passed, they may file the affidavit and it may come up for admission.
No, in 4 and 5, there is interim order.
Yes, Your Lord.
And in response,
In 5 and 6, there is interim order already.
and in
Last-
item 4,
And item 4, last day he was not there, so his junior prayed that on Monday, on Wednesday, he'll be there, that's
all
why.
right, heard Miss ML Gop learned counsel.
I have
for
placed a similar order, Lordship, in
writ petitioner appearing in all these writ petitions. Also heard Dr. B N Gogoi learned standing counsel GST authorities appearing for the respondents in item 4 and Miss R M Decca learned standing counsel GST authorities
I am not standing, but I am on behalf of Mr. S. T. Vyas.
and Miss R M Decca learned counsel appearing for the GST authorities in items 4 and 5. The learned departmental counsel have submitted that considering submitted that affidavit on behalf of the department has already been prepared and shall be brought on record within a week's time. Therefore, a request has been made to post these matters again after 10 days. Ms. Gope has agreed to the request made by the departmental council, but submits that a similar interim order as operating in items 5 and 6 be passed in item 4 as well. Full stop. Taking note of the request made at the bar, the registry is directed to list these matters again on 24th of August 2023 as fixed items for motion. Interim order passed earlier in item 5 and 6 to continue till then. In item 4, you write, likewise, operation of the impugned order dated 27/2/2023 in
7/11/22, my lord.
7,
Annexure 6, page 114.
7/11,
7/11/22.
7/11/2022. Involved in item 4 shall remain suspended till the next date. fixed.
I'm extremely sorry, Lordship.
You are
The
making a
adjudication
wrong-
order is 27/2/20
February.
2023.
Then when the court dictated it, why did you interfere?
I'm very sorry,
Is
extremely.
it overconfidence getting into your
No, my lord, not at all.
27/2/2023 shall remain suspended in the next listing.
Much obliged.
Where is he? Where is Swati Vidhan Barwa? Uh, Can you inform the council? Can you inform me? There is urgency in the matter, so whichever be the bench, it should be listed.
Item 7 and 8.
Here in the case, my lord, I have received a copy of the affidavit yesterday at 2 o'clock, my lord. So we need to file reply, my lord, at least 3 days time be granted to us. my lord.
They are entitled to, but otherwise admittedly, my lord, they are in process, they are inside a forest, reserved forest. We have annexed the map also, satellite map, my lord.
Map is not like that, my lord.
That is
Map
where-
in other ways.
Mr. Jai Borwal, counsel for the writ petitioner submits that the affidavit filed in this case in terms of the order dated 2/8/2023 has been served upon him only yesterday, and therefore 3 days time be granted for filing,
Wednesday, my lord.
rejoinder.
Right.
Accordingly, Mr. Borvia seeks posting of this matter again on Wednesday, that is 16th of August 2023. Since there is urgency involved in this case and Mr. Goswami has also agreed to the said request, it's registered to list the matter again on 16/8.
On Wednesday, my lord, interim order passed earlier to
Interim
be
order passed earlier to continue till then.
obliged.
Item 9.
May I please your lordship? Lordship, in this matter, standing as Mr. Das is on legs, lordship. Lordship may kindly pass over the matter for the time being, lordship. Otherwise, we have received the instruction, lordship. Item number 9.
Item 10.
May it please your lordship, my industry is closed because of the drain they have constructed in front of my industry, page 66. Is the photograph now, page 66.
So why did you not come when they started the construction?
My lord, we thought that they will put a culvert over it, but they have kept it open.
Who is the PWD council here?
Last time Buddha was there.
Huh?
Buddha was there, but he's not.
Buddha.
Buddha.
Can you extend an invitation to him?
Definitely.
And me?
Item 11. Item 11.
Yes, who's appearing in this case?
Item 11.
Time being, password for the time being.
Item 12.
May I please?
My lord, in this case, the petitioner, the owner of 3 bighas of land, my lord, and he's also occupying some portion of land covered by DAG number 487, my lord. So, my lord, but he has, and the transmission poles are installed in his land, my lord, in 487 as well as 523, my lord. He has been issued, my lord, notice in respect of 487. But so far, the 3 bighas of land under DAG number 523 is concerned, he has not been issued any notice, nor any compensation has been paid to him. He has requested the, my lord, the authority
You have received 7,17,600.
for, my lord, 487, my lord. For DAG number 487. My lord, I am approached, petitioner approached the, my lord, revenue authority as well as, my lord, the AGSCL, my lord. Now they are shifting the liability on each other, my lord.
Your lordship, I am appearing for AGCL, your lordship. The remaining, the DAG number he has claimed, your lordship, already we have communicated to the circle officer. We have not received any instruction from the circle officer. Your lordship.
All right, then we'll issue notice.
Yes, yes.
Mr. Jesse Goel, learned counsel for the lead petitioner. The petitioner's case, comma, in a nutshell, comma, is that due to drawing of high tension line over a plot of land measuring 3 bighas belonging to the petitioner, the land has been devalued, Mr. Although under the relevant statute, petitioner was entitled to receive adequate compensation, yet the respondents have paid compensation only in respect of the land covered by DAG number 487 of Patta number 31 of village Borimakha in the district of Baksa, whereas no compensation has been paid to the petitioner till date for the remaining area of land. Hence is the petition seeking a writ of mandamus. Mr. Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam, has appeared for respond number 1. Ms. K. Fukan, learned
5 and 6.
standing counsel,
AGCL.
AGCL, has appeared for respond numbers 5 and 6 and prays for some time to seek instruction in the matter. Miss S. Borua, Mr. S. Borua, learned G. Assam, has appeared for respond numbers 3 and 4 and made a similar request. In view of the above, you should notice of motion returnable in 6 weeks. Since the respond numbers 1, 3, 4, 1 and 3 to 6 are already represented, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the learned department council. Petitioner to serve a copy of the writ petition along with a written up notice upon learned standing council. Mr. Nayak, will you accept notice on behalf of BTC?
Yes, Lord.
Since Mr. P. Nayak has appeared and accepted notice for respond number bracket BTC, service of notice is deemed to be complete in this case. Extra copies, etc., obtaining instruction, filing at.
Item 13.
May I please?
Yes.
This matter is pertaining to one appointment of public prosecutor in the district court of Dhubri.
Appointment of, why this matter has come before this court? This is a service matter.
Service bench 3.
Appointment of public prosecutor, is it a bench 5 matter?
My lord,
Why this case has been listed before this bench?
I don't know. Sometimes bands, my lord, mix.
No,
Yes,
that,
three,
that
four.
is correct. There is some bifurcation now,
Yes.
but
Therefore,
in any case, this is not a matter coming
Bench
under.
three
bench-
matter.
Bench three matter.
Bench three.
Let it go for the appropriate bench.
Otherwise, at this stage only notice will go, lordship may issue.
That's not the point. Point
Right.
is, the court should follow the jurisdiction.
I am not difficulty.
Heard Mr. A.I. Uddin, learned counsel for the petitioner, and Mr. D. Madhinder, learned additional AG Assam, appearing for the respective parties, who have pointed out that this matter pertains to civil bench three, but has been wrongly listed before this court today. Register to verify and list this matter before appropriate.
Dates. Any date has been fixed?
It is motion matter. You come. You want a particular date?
Let it come day after tomorrow.
Day after tomorrow.
May please, item number 14, Lordship.
Yes.
Lordship, impugn communication, Lordship, they have tried to enlarge the scope of Assam Minor Minerals Concession Rules 2021, Lordship. We have approached with similar petitions, Lordship, already interim protection has been given.
No, but what is the matter? You have to say.
Lordship, this is regarding recovery of forest royalty beforehand while applying for building permission. Lord. This is not applicable to the private agencies or private individuals. It is only for the contractors, government contractors. Lordship. The Lordship may kindly peruse the rules, amended rules at page 32, Annex 1, Lordship.
Yes, who is appearing in this case?
Forest.
I'll just seek some time to get the instructions, Your Lordship.
The similar matters, there are series of similar matters and interim order has been granted.
Heard Mr.
D. Burwal.
D. Borua, learned counsel, appearing for the writ petitioner. The instant writ petition has been filed inter alia assailing the notification dated 02/03/2023 issued by the Joint Secretary to the Government of Assam, Mines and Minerals Department, thereby enlarging the scope of the Assam Minor Minerals Concession bracket amendment bracket close rules, 2021, and providing that forest royalty would be collected from government and private agencies until further orders. Mr. Borua submits that similar writ petitions assailing the notification dated 2/3/2023 are pending before this court, wherein interim orders are operating, and therefore a similar order be passed in the present case as well. In support of his argument, Mr. Borua has produced a copy of the order dated 7/8/2023, passed in WPC number 4468 of 2023. I have perused this same. Mr. D. Bora, learned standing counsel GMC, and Ms. M. Kalita, learned standing counsel Forest Department, Assam, have both admitted in their legal fairness that similar matters are pending before this court. But both the councils have prayed for 4 weeks time to obtain instruction in file action. In view of the above, NON 4 weeks, since Mr. Bora has appeared, since Ms. Kalita has appeared and accepted notice.
I have been with 3 and 9, 3 and 6.
That's for number 1, 2.
I'm for 1 and 3, Your Lordship.
You are for
1 and 2, Your Lordship.
1 and 3. Mr. S. Bora.
For 3 and 6.
That's for numbers 3 and 6. And who's for 5? 2 and 5.
Oh no, mine's mineral little.
So you are for 1, 2.
I'm only for 1 and 2, Your Lordship.
Mine's and minerals.
And you are, Mr. Bora, you are for
I am for 3 and 6.
3 and 6. And who is for 4 and 5? And
and
Mr.
government-
S. Purva, learned government advocate Assam, for respond numbers 4 and 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned departmental council requisite in numbers so as to enable them to obtain instruction. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that NOC to the petitioner would not be withheld until further orders due to non-payment of forest royalty. Let this matter be listed along with WPC number 4468 of 2023 and the batch of connected writ petitions.
Exactly.
This is also similar. But
Same order.
here two numbers of petitioners.
Writ petitioners.
Much or less.
List along with-
Item 16.
My lord, the petitioner is the owner of a plot of land, my lord, which is presently classified in the agricultural class. Because the land all in the vicinity, my lord, are already converted to commercial. He had applied, my lord, for a conversion. The conversion premium after verification was also deposited, my lord. That was in Annexure 4, my lord. Annexure 4 is the letter asking
What
you
is
to
the
deposit.
grievance? What is-
My grievance is that after payment of the conversion premium under Rule 5(7) of the Assam regulation and reclassification of non-agricultural land, my lord, NOC is to be issued by the deputy commissioner. That NOC is not forthcoming, my lord.
So will you obtain instruction? Will post-
Yes, but he has not submitted any representation before the authority lordship.
Oh, forget it. He has deposited the premium.
My
That is
lord.
the biggest representation.
My lord.
Why the NOC is not given?
Yeah,
Find
notice
out.
may go.
No, we'll keep it for motion.
My lord.
On,
Yes, instruction.
yes. On 21st for motion.
20.
My lord.
Heard Mr. K. B. Patel, learned counsel, B. Patel, learned counsel for the petitioner, who submits that despite payment of premium for conversion of the agricultural land of the petitioner, the deputy commissioner of the district has not issued the NOC as a result of requisite NOC, as a result of which the land is would not be converted in accordance with the provisions of the rules. Full stop. Having regard to the limited nature of grievance expressed in this writ petition, this court is of the opinion that the learned government advocate might be asked to obtain preliminary instruction responding to the grievance expressed in the writ petition. As such, Ms. S. Borwal and the government advocate appeal to obtain instruction as to the reason why no NOC has been issued by the deputy commissioner. That is respond number.
Two.
Respond
Deputy
number
commissioner is 2.
Two.
till today. 2 extra copies of the writ petition will be furnished to Ms. Borwal during the course of today. List again on 20. Ms. Upodiva, Ms. G. Hanunika, learned SC, Revenue Department, Assam is present on behalf of respond number 1. List is matter for motion again on 21/8/2000
Lordship, SC revenue may be reflected in the cost list.
by reflecting the name of learned department council in the cost.
I'm obliged.
Item 17.
My lord, here, my lord, we have challenged the restitution certificate of the private respond number 6, my lord, as per the government guidelines, my lord. All the societies, fisheries societies, my lord, they have to reorganize, my lord. And without reorganized, my lord, their society cannot be legal, my lord. So to that effect, we made a complaint to the authorities, recent also complaint, my lord, that has not been acted upon. That is my only case, my lord.
What is the complaint?
Complaint lordship will see at recent complaint which I have given, my lord. That your lordship will see, it starts from page 42.
No, but this complaint is to be looked into by registrar of cooperative society.
Register also, government also, register also, my lord, he did not act upon.
Where is the representation to the registrar?
That your lordship will see page 48. Prior to that also, we have approached, my lord.
Yes, what do you have to say, Mr. Rajkumar?
Yes, Lordship will kindly come to page 47, their prayer portion in the representation, Your Lordship. At serial number 10. It is humble request, Your Honor, kindly to cancel the registration of the Rangagora Fishermen Cooperative Society under the provisions of section 94 within bracket 2, Roman 4 and other rules which is in force. So Lordship, if we come to section 94, Your Lordship, it says cancellation of registration. Subsection 2, Your Lordship, the registrar after an inquiry has been held under section 87 or after the inspection has been made under section 88 may cancel the registration of a society which at number 4, Your Lordship, Roman 4, in his opinion, ought to be dissolved. Now then, an order was passed earlier, Your Lordship, subsequent to first round of litigation, Your Lordship. That order is at where the page number 39, Your Lordship. This order was passed in
Then
the
you file your affidavit then.
Lordship.
It cannot be disposed of today.
No.
Lordship, I'll take instruction.
All right. I heard Mr. Jay Borbia, yes.
Lordship, including my lord, prayer for interim to be also issued. Notice on prayer.
Heard Mr. Jay Borbia, counsel for the petitioner, produce the amendments made in the writ petition. The petitioner is basically aggrieved due to inaction on the part of the authorities to take cognizance of the representations submitted by it, requesting cancellation of registration of the respondent number 6 cooperative society on the grounds mentioned therein. Mr. R. Rajkumar.
V. Rajkumar.
Rajkumar and his standing council corporation department has raised for some time to obtain instruction and file affidavit. Prayer allowed NOM 8 weeks. Since Mr. Rajkumar has appeared and accepted notice for respondent numbers 1 to 5, no formal notice, extra copy steps by registered post with AD for service of notice upon respondent number.
Notice.
Part of the share of interim relief, issue notice on the said prayer, returnable on the same date.
Respond number 6, I have to take step by registrar. Last.
Oblige. Your
Yes.
My lord, perhaps it is a bench 4 matter, my lord.
It is pointed out at the bar that this writ petition pertains to civil bench 4 but has been wrongly listed before civil bench 5 today. Registry to examine and list the matter before the appropriate petition.
May I please the Lord? My lord, we are aggrieved by the order dated 14/7/23 passed by the Honorable my lord Customs, Central Excise and Service Tax Appellate Tribunal. My lord, what was happened in this case, Lordship? Initially, a SOCOS notice was issued in 2013, my lord, seeking reversal of SANVED credit, Lordship, saying that, my lord, the documents which we have submitted before the authority for claiming SANVED credit, that was not proper document under the SANVED credit rules 2004. My lord, we have appeared before the adjudicating authority. We submitted our reply. Various judgments were cited, and being satisfied that proceeding was dropped, which was initiated by the SOCOS notice, Lordship. Thereafter, my lord, department has preferred an appeal before the appellate authority. Initially, that was allowed by an ex parte order against which we came before this Honorable High Court, and High Court has remanded the matter back to the Commissioner Appeals, Lordship. Thereafter, my lord, after giving an opportunity of heart to the petitioner, my lord, the appeal was disposed of by setting aside the order passed by the adjudicating authority by dropping the proceeding, my lord. So, my lord, against that order, we went before the Honorable Tribunal, my lord, seeking that order passed by the Commissioner Appeals, my lord, which has set aside the order of the adjudicating authority, my lord, which dropped the proceeding, my lord. My lord, by the impugned order dated Lordship 14/7/23, the Honorable Lordship Tribunal has directed us to pre-deposit of the 10% of the disputed duty, my lord. Well, in this case, Lordship, there was no duty confirmed by any of the order, Lordship, either by the adjudicating authority or by the Commissioner Appeals, my lord. What was happened, my lord? The Commissioner has only set aside the orders which dropped the proceeding, Lordship, that was sought to be initiated by the SOCOS notice. So, my lord, naturally, my lord, as on date, there was no confirmed demand, my lord, and it only revised the SOCOS notice, Lordship. And no fresh order has been passed either by the adjudicating authority or by the Commissioner Appeals, my lord. So as on date, there is no such demand, it only revives the SOCOS notice. And in fact, my lord, The Honorable Tribunal, right, order dated 14 July 23, your lordship may find it page 89, lordship. The relevant portion, page 90. May I read, lordship? Further, it is seen that the appellant has not made pre-deposit against the contested amount of rupees so and so. The learned advocate appearing for the appellant submits that since the adjudicating authority has dropped the proceeding, which was subsequently set aside by the Commissioner of Appeals, the appellant takes the view that as on date, there is no confirmed demand and hence no pre-deposit is required to be made. I find this argument to be erroneous. The initial dropping of the proceeding under so-cause notice has been set aside by the Commissioner of Appeals. Therefore, the demand made under so-cause notice stand confirmed as on date. Lordship, we are aggrieved by this observation, my lord. My lord, so-cause notice, my lord, only initiated proceeding, right, my lord. That has to be adjudicated and my lord, the subsequent order needs to be passed, my lord. My lord, without any positive order, without any demand, my lord, the Honorable tribunal has heard in law. Lordship, in this application, my lord, our limited prayer is, my lord, lordship may direct the Honorable Tribunal, my lord, to hear the appeal on merit, my lord, without this pre-deposit. Otherwise, lordship, your lordship will find the relevant provision for pre-deposits. That is section 35F of the Central Excise Act. We have quoted, my lord, at page 22 of our petition.
Yes, Mr. Kyle,
Lordship,
this 10% is of what?
Lordship, before that, Lordship, appeal lies before the division bench under section 35G, Lordship. Against the Lordship, the opening language of section 35G, an appeal shall lie to the High Court from every order passed by the appeal by the tribunal, appellate tribunal.
Lordship, may I pray, lordship? Lord, certainly appeal lies before this honorable division, my lord. My lord, however, lordship, under 226, my lord, the exceptions, my lord, which have, my lord, as per the Supreme
Mr.
Court.
Chetia, when appeal is provided,
Lordship,
226 cannot be resorted to. I can get you those judgments. if you want.
lordship, lordship,
But
in
it will
fact,
be just wastage of time.
lordship,
In company appeals, in IT appeals,
lordship,
there are a number of judgments which
Lordship,
says when there is an
lordship,
appellate remedy, writ court will not exercise.
my lord,
extraordinary
my
jurisdiction.
only submissions, my lord, since we have reached only on the
So why
preliminary,
don't you file an appeal? This is a question of law you are
Lordship.
raising.
lordship.
What is the reason why you can't file an appeal?
Lordship, since, my lord, the order passed by the tribunal, my lord, it's a grossly illegal, my lord. So without, my lord, entering into the issue, my
Then
lord.
we'll issue notice on maintainability. There can't be an interim order. You will be unnecessarily wasting time of your client.
In fact, my lord, matter is fixed on 14th of August. before the-
Can't help it. Can't help it.
Lordship, may I pray, my lord, it may be converted into an appeal, my lord, and let it be posted before the.
No, it will, but then the appeal will have to be on a question of law.
Yes,
Lord.
You don't have the pleadings here.
Lordship,
File an appeal tomorrow and get it listed.
lordship,
You see, these are unnecessarily, the main issue will be somewhere
lordship,
else and the entire arguments will be on this.
lordship.
But if you want, you can still argue.
My lord,
But you'll have to satisfy the court on that.
lordship, lordship. My lord,
Otherwise, there is no difficulty in appreciating your submission on that
Lordship.
count. Merely because there is a notice, there is no question of 10%.
lordship.
There is no question.
Lordship, my-
Notice is your demand. It has to be adjudicated by some mechanism established under the law. Then only you can demand a percentage of that. It's a demand on demand without any adjudication. It's not permissible, but yes, you,
My lord, my only submission, my lord, the exceptions, my lord,
no, just because the court is accepting your
Lordship.
contention on merit.
Lord, if any authority passes any order, my lord, which is grossly illegal, then my lord, 226 is.
No,
applicable.
when appellate remedy is provided, Mr. S. Chatia, learned counsel for the petitioner, has appeared and has argued that the operative part of the order dated 14/7/2023 is grossly illegal in as much as there is no determination of any amount due and payable by the petitioner till now. Hence, the question of depositing 10% of the amount does not arise. Mr. S.C. Kyle, learned standing counsel, Central Excise Department, on the other hand, has questioned the maintainability of the petition by contending that under section 35G of the Central Excise Act 1944, the order of the tribunal is appealable. Full stop. This said proposition has not been disposed of, has not been disputed by Mr. Chetty. If that be so, due to availability of alternative statutory remedy, this court is not inclined to entertain this writ petition filed in writ petition under Article 226 of the Constitution of India. As such, granting liberty to the petitioner to file appeal. If so advised, this writ petition stands deferred.
Deeply agreed.
May it please your lordship. This relates to issuance of the exemption certificate under section 10 of the Income Tax Act. Lordship, we are a board which has been established as a statutory board, which has been established under the Regulation of Employment Conditions of Workers Services Act. Lordship, this is the board we are and we make welfare services to the workers. And the money which we get is a cess collected from the employers who carry out construction activities and interest from bank. Now, Income Tax Department has issued assessment orders in respect of the money which we have earned by way of fixed deposits. That is a mandate we have to follow as per the Act. Now, Lordship, section 10 of the Income Tax Act provides for granting of exemption. And as per that, we had come to this to Honorable Court before, and after the Honorable Court's direction, we were granted an exemption, which is at Annexure 9, page 67. But Lordship will find that we were given exemption from the years 2021-22 onwards. Unfortunately, for the years from 2012, when the board was set up, we have not been granted exemption. My simple case is that I should be granted exemption with retrospective effect, as has been done in case of other boards also by the Central Excise Central Board of Direct Taxes. And that is my basic prayer, Lordship. And I have made a number of applications and petitions to them, which are still pending.
Admittedly, by Annexure 9, exemption was granted from the financial year 2020-21, Lordship. And for the period which the notice was issued for demand was raised, this was relating to 17 and 18.
But
for that period, there was no exemption was granted, Lordship.
But our petition application is pending.
Application is pending where?
Before the Central Board of Direct Taxes.
Annexure
for
10.
grant of
Annexure 10,
Annexure 10.
page 68.
Because obviously it was due to inadvertence, because in case of other boards, they have been granting exemption even with retrospective effect.
So is there any demand now?
Yes.
Yes, Lordship, there's a demand, huge
There's a-
demand, 1 crore plus.
Where is the
Yes.
demand?
Page 13.
Page?
Page 72, Annexure 11.
13 is also given. Page 81.
81 also. So these demands are there.
Yes, what do you have to say?
Lordship, admittedly, there is no exemption during that
That
period.
I know. That's why
Hmm.
I'm coming
So
for your
the
lordship.
Income Tax
So, but,
Department,
what is the fate of their application made before
that
the?
Lordship, actually, I am not aware, Lordship. That was to the Central Board direct, it was, a representation was submitted before the board, Lordship.
That's what I'm supposed to.
So let the board take a decision. Till
Lordship,
then,
Yes,
Yes, that is till
you
there.
can dispose of the matter.
yes,
Yes,
I heard Ms. M. Hazarikal and Senior Counsel assisted by Ms.
Key lawyer, your lordship.
Learned Counsel appearing for the writ petitioner. Also heard Mr. S.C. Kyle, Learned Standing Counsel Income Tax Department, appearing on behalf of the respondents. Appearing on behalf of all the respondents.
Lordship.
Yes. The writ petitioner. Is a board constituted by the state government of Assam in respect of for carrying out certain specified objectives, which includes welfare
Yes,
of the welfare of labor,
labor lordship,
la-
construction workers.
welfare of construction workers, etc. As per the petitioner, the board is entitled to exemption from payment of
Income tax.
income tax on
Income tax, lordship,
Income
total income
tax.
tax. On
under
the money which it gets,
income tax on the receivables
receivables.
under
Section 10,
section 10
46.
of the Income Tax Act
1046.
10
Within bracket 46.
bracket 46 bracket close of the Income Tax Act 1961. Accordingly, by notification dated 10/11/2021, exemption was also granted to the petitioner board for the financial years 2021-22, then 22-23, 23-24, 24-25, and 25-26. First up. However, notwithstanding the entitlement of the petitioner board for exemption, no such prayer has been granted for the previous financial
Previous-
years. On the contrary, submits Ms. Hazarika, a demand for payment of an exorbitant amount. What is the total demand?
1,08,55,000.
No, it
I
is
don't know,
one
lordship.
1,08,000,000
crores, lordship, I think.
108,
My,
55, 80, 663
it's too big a number for me, lordship.
has been raised by the IT authorities with retrospective effect, thus causing enormous hardship to the petitioner board. First up, Ms. Hazarika has also pointed out before this court, the application submitted before the Central Board of Direct Taxes. Which page is the application?
Page 10, lordship.
Page 10. Page 10. or
Sorry,
Annex
Annex 10, page 68.
Application dated 26/9/2022, submitted by the petitioner before the Central Board of Direct Taxes, seeking exemption from payment of income tax for the preceding financial years. However, no action has been taken. However, the learned senior counsel for the petitioner submits that the application is yet to be disposed of. It is in that context, Mrs. Hazarika submits that if the impugned demand notice is not stayed till disposal of the application pending before the CBDT, the same would result into serious injury to the interest of the petitioner. First up, Mr. Kyle, learned standing counsel, Income Tax Department submits that the petitioner board has been granted exemption for the period during which the statutory provisions had permitted so. However, the learned departmental council has fairly submitted that until the application submitted by the petitioner before the CBDT is disposed of with a reasoned order, there will be no finality on the issue. First up, taking note of the submission made at the bar and as agreed to by both the sides, this writ petition is being disposed of by providing that the application pending before the CBDT dated date to so and so be considered on merit and disposed of after giving an opportunity of hearing to the petitioner. Until such time a reasoned order is passed on the said application, the impugned demand shall remain stayed. With the above observation, the writ petition stands disposed of.
Obliged.
Yeah,
One of the petitioner referring lawsuit is a graduate lawsuit and a ex-triggered labor community people lawsuit. My lord, I applied for a small piece of land.
So we have to issue notice
Like till then, lordship, status quo as well.
Status quo on what?
My lord, I am continuing with the business, lordship. I have constructed a house, lordship.
So this was cancelled without serving notice upon you.
My lord, nothing.
Yes, who is appearing for the respondents here? What do you have to say? Mr. Borwa, you have anything to say?
At the moment.
All right. Heard Mr. M. Khan, Learned Counsel appearing for the petitioner, assailing the letter dated 4/9/2021, by means of which the NOC for temporary use of land under occupation of the petitioner was cancelled. The instant writ petition has been filed, inter alia contending that the impugned letter has been issued without serving any prior notice upon the petitioner or giving him an opportunity of being heard in the matter. Mr. Khan submits that the petitioner was cultivating the aforesaid plot of land so as to eke out a living. Cultivating?
No, lordship, by DTP activity, DTP and Xerox activities, shop, lordship, business.
Mr. Khan submits that the petitioner, not cultivating, is running a shop established over the said land for eking out a living. However, due to the impugned letter, his source of earning livelihood has now been jeopardized. Mr. S. Borwa, Learned Government Advocate, Assam, please for some time to obtain instruction in the matter. NOM 6 weeks since Ms. G. Hazarika, Learned Standing Counsel, Revenue Department has appeared and accepted notice for respondent number 1, and Mr. S. Borwa, Learned G. Assam for respondent numbers 2 and 3. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Learned Department Council so as to enable them to obtain instruction and file affidavit. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, and particularly the claim of the petitioner that he is still in occupation of the land. Operation of the impugned letter dated
3/6/2023. Case 20.
Which a letter dated 3/6/2023, not 4/9/2001. 3/6/2023 shall remain suspended until further orders.
Awesome, lordship.
May please your lordship. My lord, tender was floated by the respondent number 3, my lord, for construction of apartment that's banned in the, my lord. Lordship, not my. Here, the two respondents, they've got lack of qualification, my lord, because one, the registration certificate of the contractor has been expired. And the other one, he doesn't have ECIS, Employees Insurance Scheme that certificate, my lord, he doesn't have, my lord. So they have been qualified in spite of having this lack of qualified in the bid, technical bid. In the final bid, my lord, they found that they write, my lord, that yes, I have got the lowest bid, last page of this, my lord. Last page, it reads here, Bhishma Kumar Dangal, lowest amount, my lord. Now what has happened, my lord? The authorities, in spite of having this, last page, can you have a look, last page? Last page, in the bottom left side, lowest amount quoted by Bhishma Kumar Dangal. After this, now the respondent is trying to allot the what to respondent number 4, my lord. Let my some here is today, my lord. Lordship, ask them to give the instruction, my lord. Meanwhile, status quo maintain, my lord. Lordship may examine this matter. What is that, my lord? I make oath my statement. They are trying to give it respondent 4, my lord.
Respondent number 4 is also the lowest bidder.
But when they find that I am the lowest bidder, the other criteria is also maybe, my lord, I have qualified. That's why they have written this, my lord. Price is same. My experience of things are same, my lord. That's the reason. That's why lordship may ask them to give instruction. What has happened? Why they want to give him, my lord? Just this short, my lord, prayer I have got today. If lordship find that I got merit in that case, lordship may pass constitutional order.
Lordship will take up this matter on Tuesday or Wednesday, Lordship. In the meantime, I will have my
Status quo may be maintained, my lord. Simple prayer today.
Lordship.
Heard Mr. M. Nath, Learned Senior Counsel, assisted by Mr. B.P. Bora, Learned Counsel, appearing for the writ petitioner. The petitioner and the respondent number 4 had both participated in the tender floated by the respondent for awarding the contractual work, namely within quotes, construction of headworks and other appurtenant structure at Angarkata, Montanga, Kalanadi, Anchalik Band FIS under PMKSY HKKP for the year 2021-22 in terms of the tender notice dated 26/5/2023. After processing the bid, it transpired that both the petitioner and the respondent number 4 had quoted the same price and had emerged as the lowest bidder. The case of the petitioner is that although the respondent number 4 does not fulfill the other technical qualification, yet the authorities are proposing to award the contract in favor of the.
No, my lord, that is not. The respondent number 4 also fulfills, but in terms of experience and turnover, the petitioner in a better position.
Some is that although the petitioner as well as the respondent number 4 fulfill all terms and conditions of the contract, yet the petitioner has more experience in execution of such works. Notwithstanding this, by ignoring the qualification and experience of the petitioner, the respondents are seeking to award the work to the respondent number 4. Hence this writ petition. You are for BTC?
Yes, lordship, 2 and 3 lords.
Acha. Mr. Nayak, P. Nayak, Land Standing Council, BTC, has appeared and made a prayer for posting this matter again on, when do you want it?
On next Tuesday, Lord.
Next Tuesday is 15th August. We are not.
16th, Lord.
16th August. 2023 for motion so as to enable him to obtain preliminary instruction. Mr. N. Upadhyay, Land Standing Council, Irrigation Department is present on behalf of respondent number 1. In view of the request made at the bar, this matter is directed to be posted again on 16/8/2023 for motion as a fixed item. 2 extra copies each be furnished to the learned departmental council during the course of the day, so as to enable them to obtain instruction. In view of the nature of grievance expressed in this writ petition and the projection made therein, it is provided that till the next date fixed status quo as regards the work in question be maintained.
May please.
Yes.
The crux of the matter in this case is, in spite of there being a cabinet resolution of the government of Assam conveyed to the Chief Secretary to the Election Commission of India and our representations thereafter, the petitioner's representation, the Election Commission of India is proceeding with the draft delimitation order in violation of Article 332(3) and Section 9 of the Delimitation Act. This is the first issue. And first and second issue. And the third issue, of course, my lord, is an issue already raised before the 5 writ petitions before the apex court. That is, regarding the entire manner and procedure adopted by the Election Commission of India. Then the issue was whether it is entertainable or not. It was argued. Then I'll place that order. Then notice was issued. My lord, we look at page 152 first. Is that communication of the Chief Secretary to the Election Commission of India regarding the requirement of reservation in favor of the Tiwa tribes, that is the majority tribes in the Morigaon district. Now, before I take your lordship to the requirement of Article 332(3)
and section 9, may I have the indulgence of taking your lordship to page 161. Because if I take your lordship to 161, then I take your lordship to 332(3) and section 9. I think it will be more convenient for me at this side. Your lordship will see the census is 2001. The total population in the state, I'm so sorry,
Yes,
161.
yes,
Total population in the state was in the extreme left-hand side is 2 crores 27 lakh, has your lordship.
yes,
The extreme right side, 7 lakhs 55,000 is the scheduled tribe community. Has your lordship.
yes.
Now, here, constitution here. I take your lordship to article 332(3).
Constitution.
Yes. আর এখন extra copy আছে না constitution আছে। 332(3). 332(1) will be, I'll first read out, my lord.
Yes,
The seat shall be reserved, as your lordship, for the scheduled caste and scheduled tribes, except the scheduled tribes in the autonomous district of Assam, in the legislative assembly of every state. Then your lordship will come to sub-article 3. The number of seats reserved for the scheduled caste in or the scheduled tribes in the legislative assembly of any state under clause 1 shall bear as nearly as may be the same proportion to the total number of seats in the assembly as the population of the scheduled caste in the state or the scheduled tribes of the state or part of the state, as the case may be, in respect of which seats are so reserved, bears to the total population of the state. Now, my lord, your lordship is aware that after 42nd amendment of the constitution, the total number of seats is fixed till first census done after 2026. That is 126 is the total number of seats. Now, your lordship, I will take your lordship's indulgence to take your lordship page 161. As per the census figure of 2001, 7,55,000 out of a population of 2 crores 20, has your lordship got?
yes,
Now, the proportion comes to 9.4%. That means I have to take the 9.4% of 126. I'm sorry, 7.5. I'm so sorry. I stand corrected, man. 7.5% of 126. The figure comes to 9.4. That means 9 seats have to be reserved for scheduled tribes. That 9.4, let us come down to that. Now, the crux of the matter here is why the state government had to point out in the draft, they have reserved only 7 seats. Now, how could they have done it? Your lordship will come to the last page of the petition. Morigaon constituency consists, Morigaon district consists of 3 constituencies, has your lordship got? The last page, there is Jagi Road, Lahori Ghat, and Morigaon. This is constitute the Morigaon district. Has your last page, my lord? The colored page at page number 164.
yes,
There are 3 constituencies in the entire Morigaon district. That is Lahori Jagi Road, that is at the top, Lahori Ghat, and Morigaon. Has your lordship?
yes,
Now, in the draft, at your lordship will compare it, page 163. I am taking your lordship how the section 9 has been violated. Page 163. Your lordship will see, in order to bring down the 30% population, there is a scheduled tribe. They have put some green portion here, some green portion on the extreme left, as your lordship got it. Section 9 requirement of the Delimitation Act is when areas constituted in a constituency must be contiguous. That is, this is a mandatory requirement under section 9. May I take your lordship to the Delimitation Act? Delimitation Act section 9.
you have the book delimitation.
subsection A.
Yes.
All constituencies shall, as far as practicable, be geographically compact areas. Has your lordship. The earlier, the 3 constituencies were compact areas. Now, what they have done, and I will my lord submit why it has been done. The cabinet has pointed out that
Yes.
30% of the total population of Morigaon district, I'm sorry, 15.5%, and 30% of the Morigaon constituency constituted Tiwa autonomous district, that Tiwa tribes. In order to bring it down, some villages have been now tagged to this year. Some on the, your lordship will look at page 163. On the left side to Zagi Road, on the Lahori Ghat, on the right hand side, there are some pockets here and there. All tribal pockets have been now put out. So basically, what my first two contentions, my lord. First one is violation of 332 sub-article 3. Second one is violation of section 9, subsection A. And my lord, third point, which is little interesting, my lord. Of course, this third issue is already subject matter before the apex court. I have the order copies also. Third issue is my lord peculiar. Your lordship, am I taking a lordship's valuable time? Only 2-3 minutes. Very interesting third point. On 26th of November 1949, India was declared as republic. The first duty of the government then was to make it sure that to identify the constituencies, because we are going to be a democratic republic. So therefore, the RP Act 1950 was introduced. If your lordship looks at the object clause of the RP Act 1950, saying that these are our constituencies. Now what happened? Next stage is the election. First is the determination, next is the election. So therefore, there was no law for holding election. RP Act 1951 was brought in. RP Act 1951 object clause shows the manner of holding election. Now, what happens under Article 82 of the Constitution of India? I'll just take 2 minutes.
Yes, please.
Under Article 82 of the Constitution of India, there is a mandate that after every census, there has to be a delimitation. That is Article 382. And 327 says that for delimitation, there has to be a law. For holding an election, there has to be a law. So there is a law called RP Act 1951. So the Delimitation Act 1951 was brought in under the chairmanship of Justice Iyer, who was a former judge of the Supreme Court. And the Delimitation Commission constituted presided over by Supreme Court judge, retired, and Election Commission of India and other associate members. Then we get 1962, because 61 is the next census. Delimitation Act, section 3, retired Supreme Court judge and other members, Election Commission and other members. Then we get 1972, because 71 census. Then 1976, 42nd Amendment comes in. 42nd Amendment said, by amending Article 170, that since the democratic, because basically the whole situation started because the first Prime Minister of India announced the principle that Chota Poriyal, Sukhi Poriyal. As a result of that, what happened? The southern states, they followed it. Northern states did not follow it. And because of the 1971 Bangladesh war, there is a demographic pattern change. 42nd Amendment was brought in to amend Article 170, saying that till the first census after 2026, the seat number will not be changed. That's why we are still having 126. And they said, the 42nd Amendment, that 2001 census will be the next figure. Therefore, we do not get a Delimitation Act under 82, 92. We get directly to Delimitation Act 2002. When the Delimitation Act 2002
Again, the same section, the delimitation commission will consist of a retired Supreme Court judge and Election Commission of India and other associate members. Then after the Delimitation Act, the Kuldeep Singh Commission was constituted by the President of India. Now, when the Kuldeep Singh Commission came in, as they started the exercise, there was an NRC case in Guwahati High Court. The matter came up before 5 judges bench in a PI, saying that 2001 possibly will include foreigners. Therefore, 2001 should not be the basis. The order copy, I have annexed or it is with us. We have annexed. I will come to it. So when this was on the next day, the Apex, the learned Assistant Solicitor General, he came and produced the notice that this is state. State by virtue of section 10A of the Delimitation Act, because power was not there before to stay. That stay continued. That stay was withdrawn in 2020, possibly in the month of February. I'll check the date later. So that these four states, Assam, Arunachal, Nagaland, Mizoram, Delimitation Commission was constituted by Justice Ranjana Desai Commission. When Justice Ranjana Desai Commission started, then again for reasons based on the government of India, the president stayed it because of law and order situation. Now, when it has been withdrawn, Election Commission of India, who was a member of the Delimitation Commission, he has been entrusted with the delimitation process. So entire delimitation process has been now entrusted to Election Commission of India. Your Lordship will look at section 3 for my section 3 of the delimitation. Section 3. Has your Lordship?
Yes, yes.
Yes. Section 3A. Has your Lordship?
Yes, yes.
Now, when they have started it, Election Commission of course is a member. Election Commission of course was a member. Now I pose a question to myself, that how could they have done it for my city? They introduced a section called Section 8A in the RP Act 1950, actually by doctrine of implied repeal, when in the same subject, 2 central statutes are coming in, the earlier one goes. In the earlier one, Section 8A, a section was brought in saying that President has the power to withdraw the stay order and ask the Election Commission of India to continue with delimitation. Now, for that method, the entire process and procedure adopted by the Election Commission of India came under challenge in 5 writ petitions. Only last 10 days, I had a person to be present there. A query came up, very interesting query. Your Lordship will see there is a bar, 2 types of bar. Article 329, it says that any laws relating to delimitation is not challengeable in any court of law. The similar language is again echoed in Section 10 of the Delimitation Act. Your Lordship will see Section 10. Am I correct? I am taking your Lordship's valuable time.
Yes, please.
Section 10, subsection 2. Now,
That's all right, but this the plenary jurisdiction of Supreme Court and High Court perhaps will not be taken.
I am obliged, but this is my duty, that this issue was raised by the Honorable Chief Justice of India, that delimitation, rightly or wrongly, something how it's going on, and how can we step in? Then L. Chandra Kumar, where it was summed up, then the notice has been issued on the 3rd point that I am raising now. But I thought that it is my duty to raise this and then answer it. But this is my case exactly. If you can I place, if your lordship pardon, I have the only printout copies
So
of
what is that you are seeking today? What is-
seeking today, my lord. So far the regarding the admission, it's up to your lordship prerogative, but if it is admitted, there are 30% population in Morigaon is scheduled tribe as per the 2001 census in the Morigaon constituency. And there are 3 constituencies. Now at this juncture, may I have the indulgence of praying that if they want to, because I'm not saying they stop here to create a chaos, because main issues will be determined later on. That's what the apex court has said also. So for the 3 constituencies are concerned, let them not take a call on Morigaon district for the time. Because if it is again, if it is taken a call, because it is admitted, I am not disputing 2001 census, hopefully they are also not disputing. 2001 census is the basic document. I am also, hopefully they also will not dispute the language of 332(3). That this. They will also not dispute that only 7 has been resolved and 2 are still left. They will also not dispute that section 9, the requirement of maintaining the contiguity of the areas are not maintained. May I have that indulgence of your lordship? Of course, it's a lordship discretion. That at least, I'm not saying give me the reservation, at least till the returnable date, please don't take a call in respect of 3 districts in Morigaon. That's much. 3 districts, not 3 constituencies of Morigaon district. That much is my limit. I'm also.
This is the order passed by the Honorable Supreme Court, Your Lordship, where the petition was filed challenging Section 80 of the Representation of People Act and the entire delimitation exercise. They have also in the said petition, Your Lordship, they have challenged, if Your Lordship come to page 3, para 7, Honorable Supreme Court has recorded that this is inter alia a challenge to the constitutional validity of Section 8A of the Representation of People Act. Apart from a challenge of decision which was taken on 28th of February 2020, the process which was been followed as has also been called for into the questioning. Subsequently, in page 8, the challenge, the challenge has been urged on behalf of the petitioner by Kapil Mr. Senior Counsel can be formulated as follows. Number 1, the process of delimiting constituencies under Delimitation Act provides for the inclusion of political representatives since member of parliament or as the case may be the state legislative assembly form a part of the machinery and pieces for carrying out the process of delimitation. On the other hand, where an order for referring to the delimitation process is decided in excess of power under Section 8 of RPA, the process of delimitation entrusted to Election Commission rather than the politically inclusive process which is envisaged in the Delimitation Act. The dilution of the role of the political process in the delimitation exercise, which is carried out pursuant to the provision of Section 8 of the RPA Act, would violate cardinal principles of democracy and hence the basic feature of the Constitution. The power of Section 8A of the RPA Act to rescind the department notification is entrusted to the President. In the present case, the notification dated 28 February 2020, which is issued by the Union Ministry of Law and Justice, albeit in the name of the President, indicates that the delimitation was to be carried out in accordance with the provisions of the Delimitation Act 2002. The election commission has acted contrary to terms on which the department of the delimitation exercise was decided on 28 February 2020. Number 3, Article 170 subclause 2 of the Constitution indicates that each state shall be divided into territorial constituencies in such manner that the ratio between the population of each state and the number of seats allotted to each shall, so far as practicable, be same throughout the state. Similar provisions are embodied in Article 81 subclause 2. In the present case, the draft proposal, which has been published by the Election Commission, proceeds on the density of population and doing so breaches the constitutional norms which are prescribed in the above provision. Lordship, this is the basically the draft proposal which they are challenging, Lordship. And the Honorable Court Supreme Court has critically stated in para 12, Lordship, the process of delimitation has commenced following the decision to resign the department of the delimitation exercise for the state of Assam on 28 February 2020. Section 80 of the RPA Act also makes a provision for 4 states, namely Assam, Arunachal Pradesh, Manipur, and Nagaland. For this force upon the decision of the department order, the conduct of the delimitation exercise entrusted to the Election Commission, the provision of Section 8A contain detailed provision in regard to the manner in which the Election Commission is to carry out the delimitation exercise. The provision of the process has commenced following the notification dated 28 February 2020. The draft proposal has been published on 28th of June 2023. It would not be appropriate to.
So why don't we examine this aspect of
Yes,
the
Lordship.
matter while finalizing the,
Yes, Lordship,
you can
because
close the writ petition
yes, Lordship.
by saying that you examine
Yes, Lord, that may be
in the
done.
light of Article 333(2) read with Section 9A
Yes, Lordship.
of the Delimitation Act.
Yeah.
You examine the
Okay, so they can.
issue
give the-
raised by the petitioner
Yes.
and take a decision in the matter.
Let them give
before-
the representation before the, because since it is,
It's already there.
it's already there.
Presentation is already there.
Yes, Lordship.
Are you appearing, Mr. Nath?
Because the state of Assam, proper respondent is included here. But the department, I'm told that it would be chief secretary. Here it is written health and family.
It's a pro forma.
For-
I'm extremely sorry. By mistake, it has been shown, possibly my colleague, he's all the time appearing health. And actually, it should have been chief secretary, government of Assam, not health and
If it is chief
political
secretary, I'm happy.
department. I'm extremely sorry,
But
man.
He might have been having the health of the state in his mind.
I could not get any reason on the part of my colleague what for he was doing.
If it is chief secretary, I'm happy.
I'm extremely sorry.
I'm
Well,
happy.
we'll file an
Sorry.
IA to correct the pro forma. Or by hand also.
Where is your representation?
Representation is at page 153. And may I have also one more in that they'll also take into account the government of Assam's resolution, cabinet resolution, only that much. There is a cabinet resolution conveyed to the election commission. At least cabinet has already requested them. That also will be taken into consideration.
But Mr. KP Pathak, Lani, senior counsel assisted by. Huh?
B does, my lord.
B?
Does.
B does learn counsel appearing for the writ petitioner. I've also heard Mr. R. Ali learned.
AI Ali.
Huh?
AI
A.
Ali.
Ali. A.I. Ali.
AI Ali.
And Standing Council Election Commission of India appearing on behalf of the respond numbers
1 and 2.
1 and 2. Mr. Who is the CGC here? Any CGC? Ms. S. Borwal and his CGC is present on behalf of respond numbers 3 and 4, and Mr. D. Nath Lanet, Senior Government Advocate Assam, has appeared for the respond number 5. The writ petitioner hearing belongs to the Tiwa community, which is a recognized scheduled tribe in Assam and is also a voter of the number 54 Morigao Legislative Assembly constituency. Full stop. Being aggrieved by the projections made in draft proposal dated 26/2023, prepared by the Election Commission of India in connection with delimitation of assembly constituencies in the state of Assam. The writ petitioner has approached this court inter alia contending that as per the projection made in the draft proposal, there is a strong possibility that the Morigao constituency, which was hitherto reserved for SC.
It is presently not reserved. Earlier it was reserved. In 1951 onwards, it was reserved.
Morigao constituency, Morigao, that number 54 Morigao legislative constituency, which has a majority population of scheduled tribe, has not been shown to be included in the category of 9 reserve category constituencies required in the state of Assam. Full stop. Mr. Pathak has invited the attention of this court to the representation submitted by the writ petitioner and
Page 153.
representation submitted before the Election Commission of India. What is the date of the representation?
27, 2023.
27/2023 by the petitioner is also one of the,
Yes.
no, his name is not there. He is not one of the representation.
He is not there, Lordship.
Huh?
His representation
Which
not been
page
filed.
number? So this is, I'm so sorry, I stand corrected. Madam. This is committee's representation and where is petitioner's representation? I'm sorry for your chip. Page number 126. Huh? 120.
Representation submitted by the petitioner before the ECI. Mr. Pathak, there is no clarity. Where is the representation by the petitioner?
Please come here. Huh?
Even in page number 120, his name is.
116. Are you sure? 116.
6/7/2023.
6/7/20.
6/7/2023 submitted by the petitioner. But this is by number of persons.
Number of persons.
Petitioner's name is not there.
The last signature is his signature. He is the president. Krishna Kanwar, no?
In left side, your lordship.
On the left
bottom
hand side.
Third lordship.
By the petitioner and several other voters of the constituency with a request to include the number 54 Morigaon Assembly constituency as a reserve constituency for the STs. Mr. Pathak submits that despite the receipt of such representation, no action has been taken in the matter till today. It is also the submission of learned senior counsel for the petitioner that the proposed move on the part of the Election Commission of India is not only in contravention of the mandate of Article 332(3) of the Constitution of India, but the same also runs counter to the letter and spirit of Section 9(a) of the Delimitation Act 2022. Under the circumstances, the petitioner has prayed for an interim order staying the process of delimitation with regard to the 3 assembly constituencies falling in Morigaon district. Full stop. Mr. A.I. Ali Lanet, Standing Council ECI, on the other hand, has opposed the prayer made in the writ petition by contending that in view of the order dated 24/7/2023 passed by the Supreme Court of India in WPC bracket number 51 of 2023 bracket Hirendranath Gohai and Union of India and others versus Union of India and others, no interference with the delimitation process would be permissible at this stage, full stop. Mr. Ali further submits that the stand of the petitioner is merely in response to a draft proposal which is yet to be finalized. As such, the writ petition is premature, full stop. After going through the materials available on record, it appears that this stand projected by the petitioner also finds support from the request made by the Chief Secretary Assam by communication dated 6/7/2023 addressed to the Deputy Election Commissioner of India, whereby it has been pointed out that the Tiwa tribes residing in Assam is an indigenous tribe and constitute a sizable community in Morigaon constituency. Taking note of the same, the Assam cabinet has also resolved to request the ECI to examine as to whether Morigaon LSC can be considered for reservation as a ST constituency. Full stop. The fact of the matter remains that no final decision has been taken by the ECI with regard to delimitation of constituencies and reservation of 9 assembly constituencies in the state of Assam, and the process is still under consideration. Therefore, at this stage, this court is not inclined to interfere in the matter. However, having regard to the facts and circumstances of the case and the submissions made at the bar, this writ petition stands disposed of by providing that before finalizing the draft proposal, the respondent number 1 may examine the grievance of the petitioner as reflected, grievance of the petitioner in the light of the provisions of Article 332(3) of the Constitution, read with Section 9(a) of the Delimitation Act 2002, as well as the cabinet resolution of the state of Assam, and take appropriate decision in the matter as may be warranted in the facts and circumstances of the case. With the above observation, writ petition stands.
But in this matter, I have got the instruction
What is this matter about?
They are objecting that their petitions, they filed some petitions and those were not taken by the presiding judge. But my instruction is that no proper application has been filed before the presiding judge. There was no CNR number. So how can the presiding judge take up the matter? And it is not for the presiding judge to decide whether to take up the matter or not. If it's filed properly, CNR number is given, the chief administrative officer, he will record and it will be placed before the judge. So absolutely, it appears that the non-issue has been made an issue here. Some advocate directly presented the petitions before the judge. That is not permissible now after 2014.
My lord, kindly parents page 45. This is a resolution, my lord. The bar has constituted a committee. The committee has inquired into the matter. What happened? Because the petitioner has made a complaint to the bar against the advocate. And last paragraph of page 45. The house inquired into the matter of such and such and came to know that his appeal and revision petition filed by him in such and such respectively were not admitted by the Honorable District and Session Judge Hujai and was returned without giving any written order and any number in appeal revision petition. So, my lord, initially after filing, it has to be numbered. And then only it will place before the court for judicial side, passing any order. So my case is that for a long period of time, it has not been numbered.
Where is your petition? Where is the appeal?
Appeal, my lord, I have annexed. Your lordship will find. Page 36. This is against DB case appeal, memorandum of appeal. And page 39 of
So,
lordship will find.
Mr. Das, why would it happen that they will come with a false case once the appeal is, there is an appeal ready, there is an order?
As per instruction, it has been said that some advocate directly presented the petition before the court. Now a system, online system has come, everything is done through CNR, my lord. CNR number is given and it is the responsibility of the chief administrative officer. He does numbering and filing all these things after not fulfilling all the formalities and removing defects. The matter comes to the court, my lord. The respondent number two has
You present it again tomorrow.
let them
But Mr.
file the petition proper
Counsel
format.
for the writ petitioner, there is the amendments made in the petition. The grievance of the petitioner is that the domestic appeal sought to be preferred by him under section 372 of the Code of Criminal Procedure, read with section 29 of the Domestic Violence Act 2005 before the Court of District and Session Judge Hojai Sankardev Nagar, assailing the order dated 16/3/2021 passed by the learned Judicial Magistrate First Class in DV case number 99/2015 was not entertained, nor was the same registered by the appellate authority, by the appellate court, once the same was presented by the learned counsel for the petitioner. Full stop. Taking note of the allegation made in the writ petition, Mr. H.K. Das, learned standing counsel GHC, was asked to obtain instruction in the matter. Today, when the matter is called up, the learned standing counsel GHC has produced a copy of the written instruction received by him. On perusal of the same, it appears that the learned counsel for the writ petitioner had not presented the appeal by following the due procedure for filing of appeals, as a result of which the same was not accepted. Mr. Das submits that the appeal was directly presented to the district and session judge, which is not the prescribed procedure. Full stop. The Learned Standing Council GHC submits that if the petitioner's counsel presents the appeal before the chief administrative officer,
Yes.
then the same will be registered and thereafter the file would be put up before the appropriate
Yes.
court. Mr. Uddin has also agreed to the said recourse. If that be so, no further issue survives in this writ petition for adjudication for now. As such, by providing that within 2 days from today, the petitioner may present the appeal before the concerned authority in the establishment of district and session judge Ojai. If such an appeal is presented, the same shall be registered by following the prescribed procedure and put up before the learned appellate court for passing appropriate order.
Yes.
With the above observation, writ petition stand disposed of.
Above from appeal and revision petition also. Page
Appeal.
40.
And oblique or revision petition.
Two petition are made. One is appeal, another is revision. Deep, outline.
Yes, what is this culvert? Cover it up.
Lordship, I kindly see page 76, Lordship.
Hmm.
76 or 66?
76, it is connection to Gundogul আছে, মুই at 76 লিখা আছে।
66 হবে।
It should be 66 in your
66.
lordship copy, Lordship.
66.
If you leave drains uncovered, this is what. will
Yes,
happen.
that is what, Lordship, in other photographs, that drain was not there.
No, it's stop its drain, it's water.
No, you forget the photographs. He's saying that you have constructed drains and left it uncovered.
Yes,
The result of
but
which-
it is not that ingress and outgress has already been.
My lord, my gate, in front of the gate, my lord, the water is there. Let there
Lordship,
be a
may kindly
commission,
say, Lordship, may kindly say in that building, 2 gates are there. On the right hand side, 1 gate is there. That gate is open, Lordship.
You file an affidavit, then we'll send an advocate.
Lordship will take up this matter on 16, Lordship. I have already sent my communication, Lordship. It was sent to the chief engineer's office, probably that is why it is not coming. Next date, Lordship, I am going to contact to the executive
No,
engineer.
but you have to construct a drain.
It will be Lordship, but Lordship will have to consider the fact that drain is very new, Lordship.
It was
At least some
constructed-
time required, Lordship, for
How much time? How much time?
that instruction only, Lordship, when it will be constructed, Lordship. That much only, Lordship.
It was done in the month of June, today is August, my lord. My industry is closed.
Lordship, so many photographs has been annexed, Lordship. In
Mr. Nayak, this is not this is not
Lordship.
an adversarial matter.
Lordship.
He's a-
Lordship will take up this matter on
A
16.
litigant is saying, allow me to operate my shop.
Lordship.
Uh,
No,
Or
it's
is there anything else behind it?
No, Lordship, what I'm submitting is already open, Lordship. In the second gate is open, Lordship.
That is not.
Page
that-
60.
Mr. P.K. Rochester, Learned Council appearing for the writ petition also heard Mr. P. Nayak, Learned Standing Council, PWD Assam, who praised for posting this matter again on 17/8/2023, so as to give him sufficient time to obtain instruction from the concerned executive engineer and
Lordship.
appraise this court as to whether, number one, the ingress and egress to the petitioner's
Factory, not the residence
Factory.
one.
has been closed due to the construction of the drain. And number two, the time that will be required for
Constructing the slab.
constructing a cover oblique slab over the open drain so as to allow the petitioners, so as to allow access to the petitioner's factory. The written instruction on the aforesaid 2 points be placed before this court, facilitating disposal of the writ petition.
On 17, Lordship.
Yes, 17.
May please, your lordship, this petition for non-issuance of the scheduled caste certificate, lordship. Non-issuance of the caste certificate, lordship, scheduled caste certificate, lordship. Petitioner's mother, lordship, scheduled caste community, lordship.
Petitioner
And
is
father
approached the court by expressing the grievance that his request for issuance of scheduled caste certificate has not been acted upon by the concerned authorities. Mr. N. Goswami, Learned Government Advocate. Assam,
Number 4.
appearing for respondent number 4, prays for some time to obtain instruction in the matter. NOM 6 weeks. Who is for 1, 2, 3, and 5? Who is appearing for 1, 2, and 3?
For one, standing council is there, Lordship.
Who is the standing council?
R Dhar, Lordship, Rahul Dhar. নাম তো দেখা নেই।
A copy of this writ petition along with written up notice be served upon Mr. R. Dhar Leonard SC, WPT and BC on behalf of the respond numbers 1 and 2. Since Mr. Goswami has accepted notice for respond number 4, service on respond numbers 1, 2 and 4, subject to service of notice upon Mr. Dhar, shall be deemed to be complete in this case. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within a week from today. Yes.
Order state I think.
Your Lordships, IA has been filed by the respondent. I want to file your Lordship.
Short date may be granted because Lordship, the tender itself has been cancelled now. They were aggrieved by the non-issuance of work order. We have cancelled the tender process. And
What remains in the writ petition?
Your Lordships, the minute it was cancelled, I'll bring all this, Your Lordship.
No, you file a fresh writ petition on that. Where is the order of
it
cancellation?
is there in the IA and the affidavit in opposition also.
Your Lordships,
At the IA, it is at page number 28. Your Lordship.
We'll give you liberty to file a fresh writ petition.
Your Lordships,
No, you
the
can't.
manner in which it was cancelled, Your Lordship, the manner in which the order of the Honorable Court has been flouted, Your Lordship, I want to bring it in this case, Your Lordship.
You cannot bring it in this case. We will not allow you because that is not permissible. You cannot ask for anything you feel like. Heard Mr. KP Pathak, learned counsel for the applicant. Also heard Mr. NN Jha, learned counsel appearing for the OP writ petitioner. Mr. Mr. K. Gupta, learned counsel is present on behalf of OP numbers 4 and 5. This IA has been filed with a prayer to vacate the interim order dated 16/3/2023. Mr. Pathak and counsel for the applicant submits that,
Order is at 12/4/2023.
sorry, 12/4. Which page is the order?
30, Your Lordship.
Order dated 12/4/2023. Passed in WPC number 2034 of 2023. Mr. Pathak submits that the petitioner was aggrieved due to non-issuance of the work order in his favor in connection with the tender dated 28/1/2023. However, the tender process has already been cancelled and therefore the writ petition has become infructuous. First, Mr. Jha, however, submits that the process adopted in cancellation of the tender is highly arbitrary and illegal and has violated the fundamental rights of the petitioner. First, be that as it may, if the writ petitioner is aggrieved by the order cancelling the tender, the same would give rise to a new cause of action which can be agitated in a fresh writ petition. However, once the tender is cancelled, nothing survives for adjudication on the facts pleaded in the writ petition. To that extent, the IA also has become infructuous. To that extent, the interim order dated 12/4/2013 has also become infructuous. In view of the above, the writ petition stands disposed of as infructuous by granting liberty to the writ petitioner to assail the order of cancellation of the tender by filing a fresh writ petition if so advised. In view of the order passed in so and so, I will spend. You can file another writ petition.
Your Lordship.
Right, you should identify.
Yes, ex gratia, what is your instruction?
In this matter, the SP was supposed to file an affidavit, Your Lordship, the government advocate. The SP of the Kokrajhar district was supposed to file an affidavit, Your Lordship. According to that affidavit, Your Lordship, the death was caused by strangulation, the postmortem report. Also, Your Lordship, it is not proven that the death was caused by some miscreants. It can be a murder also, Your Lordship. That has not been, an investigation is still on.
But then if the SP doesn't file a affidavit, then what to do?
Yes, madam.
Heard Mr. M.K. Hussain, learned counsel for the petitioner, also heard Ms. N. Bordelais, learned SC Revenue Department, Assam, appearing for the respondent number one.
Listen to petition.
Mr. S. Bhuvan, learned government advocate, Assam, appearing for the remaining respondents as paid for further 4 weeks' time on behalf of the respondent number 4 to file an affidavit. Full stop. Prayer allowed as last opportunity. If the affidavit is not filed within 4 weeks from today, this court will consider directing personal appearance of the respondent number.
Actually, my lord, SP has filed the affidavit.
We have
on
filed it.
28/7, madam.
Yes, we have.
28/7/2022, the SP has.
Then
filed
why
it.
have you said? no?
My lord, in this.
We have submitted.
SP has not filed, Your Lordship.
My lord,
Has
phase
filed.
2 of
Superintendent of police, it has been filed way back in 26, seven.
SP and superintendent of police are two different authorities.
No, my lord, same person.
Why are you making a wrong submission, Ms. Bordelais?
It has been filed.
But in the affidavit said, my lord, the actual culprit involved in the murder of the aforesaid victim as well as the actual cause of crime yet to be ascertained.
Have
That
you
is why,
filed
my-
your, have you filed your rejoinder?
yes, my lord.
You filed rejoinder.
Not
Have you
yet-
filed your reply to the affidavit?
Not yet.
You want to
filed.
file?
Not yet filed, my lord.
Then we'll close the matter, saying that
My
after the cause of death is ascertained, then you the petition.
Not, but the investigation is going on, my lord.
Then this is not in order.
Investigation is going
So
on.
and so up to, I'll be responding up to that.
My lord, and also investigation of the case is going on, my lord. My lord, phase 2 of the affidavit.
So what is to be done now?
My lord, the investigation is going on, my lord. The further affidavit is required from the SP.
There was the statements made in the counter affidavit filed by the respondent number 4, which goes to show that investigation in connection, in the connected police case being PS case number
26.
Pokrajar PS case number 26/2020 is still under progress so as to ascertain the cause of death. First up, since the cause of death would have a relevant bearing on the claim for asphyxia compensation made in the writ petition, this matter stands deferred by another 6 weeks so as to enable the police to complete investigation. An updated status report be presented by the respondent number 4
After 6 weeks.
after 6 weeks.
Obliged.
Updated, a status report on the stage of investigation be presented by respondent number 4 after
May-
6 weeks.
May it please, Mr. Lordship, my lord. My lord, here, my lord, we have challenged the order, my lord, at page 103, whereby, my lord, the petitioner also, my lord, wanted to contest the election for the cooperative society, my lord, Dibru Dangori River Part 1 Min Mahal Society, my lord. But, my lord, the petitioner's my lord, nomination was illegally rejected by wrongly applying the provision section 40 subsection 2.
So what is to be done? Disposal today?
Well, last occasion was also, my lord, cooperative society was not present. I will inform, my lord, next week, my lord, meeting will be.
Who is not
Because
present?
Cooperative society, my lord, Mr. Talukdar is there. On 19/7 also, he was not present. And in fact, has not filed affidavit.
You call him then, we'll take it up.
Yes.
Or what, some other day?
Or, my lord, I will inform, my lord, on my lord, Wednesday, my lord, maybe
Oh, we can't.
Wednesday.
Mr. B.K. Das, Learned Counsel appearing to the petitioner submit that since the issue involved in this writ petition lies in a limited campus, the matter can be taken up for disposal at the stage of admission hearing. Srimati U. Borua, Learned Senior Counsel, is present on behalf of respondent number
7 and 8.
7 and 8. However, the Learned Standing Council Cooperation Department, Assam, is absent, although his name has been shown in the cause list. In view of the above, let this matter be listed again after 2 weeks
Wednesday.
for admission.
Yes.
Item 28.
May it pleases your lordship, as for the last order of the honorable court, we have filed
an additional affidavit yesterday enclosing the contract agreement, your lordship. In the meantime, they may.
That is not on record. Is
P Hazarika.
P. Hazarika Learned Counsel for the petitioner submits that as per the last order of the court, an additional affidavit enclosing the copy of the agreement has been filed by the petitioner only yesterday, but same is not on record. In view of the above, registry to tag the additional affidavit with the record and list the matter again after 10 days. In the meantime, Mr. P. Nayak Learned SC PWD, is it?
Lordship.
PWD to seek instruction on the additional affidavit.
Item 29.
Well, in this matter, a joint house was there. A part was of my nephew's and another part is of the petitioner. And recently, due to the expansion of the highway, part of the nephew was demolished, but the department says that I am beyond the raw line, right of way line. I'm not within the highway line, right of way line. But the problem is that because this is a common house, my part also has been affected. I have shown the photographs. That is that, my lord may kindly give it. Before that, my lord, the statement of
So today what is to be done?
my lord, my limited prayer is that the deputy commissioner has directed the circle officer to verify whether my part is of damage or not. Deputy circle officer has directed the PWD and the matter is pending before the PWD. My limited prayer is that if direction is given to the
PWD is not part in that.
but deputy commissioner is the party and the authority is deputy
After
commissioner.
hearing the submission of Mr. D.K. Nath and in view of the controversy involved in this repetition, registry is directed to list this matter again after 2 weeks by reflecting the name of Mr. P. Nayak, Learned Standing Council, PWD Assam in the cause list. Two copies of the writ petition were furnished to Mr. Nayak so as to enable him to seek instruction and appraise this court as to whether the report called for by the deputy commissioner of
Well, was submitted or not. If not
Golaghat-
submitted.
has been
Annexure 4
submitted
page
or
18.
not. And if not, the reason thereof. He says it is in the PWD. Just tell us this much. That's
That is, my lord.
yes. Mr. Yes, Mr. S. Burwal, Learned G. Assam and Mr. Talukdar, Learned Standing Council, NHI DC are present on behalf of the respective respondents. Yes, you gave him the copy.
My lord.
Item 31.
Wait, please, your lordship. This matter, your lordship, the petitioner who has got a permission to build his house, G+3. But some persons who are also members of the board, municipal board has created problems that he was not allowed to dig his deep tube. Already permission has been granted to him by the municipality. So we filed application before the police. The police have filed their affidavit, but the board has not yet filed the affidavit. We have taken Dusty step also. In that case, I have also filed the affidavit with regard to service of Dusty upon the Golaghat Municipal Board. And Golaghat Municipal Board. Golaghat Municipal Respondent number 4, private respondent. Only this one. I mean, Dusty service on all the respondents. Except the, you are appearing for whom?
I am for the respondent number 3, lordship.
They have filed the affidavit. Superintendent of police, they said that there is an issue. And so they have referred the matter for to the executive magistrate to decide under section 107 with regard to the creating ruckus in the area. Now, with regard to building my building using the deep tube well, that is stuck. So they should at least give us the permission to go ahead with that. So I think the Golaghat board has to come. We have already taken the steps. Then we'll ask one more verification and listing along with the name of counsels if any. Mr. Y.S. Mandal, Learned Counsel for the petitioner, has invited the attention of this court to the affidavit filed on 15/3/2023 after completing dusty service of notice upon respondent numbers 1, 2, and 4. I perused the same. It appears that service of notice by means of dusty is complete on respondent numbers 1, 2, and 4. Mr. N. Goswami Lanet G. Assam is present on behalf of the respondent number 3, registered to verify as to whether any council has entered appearance for the respondent numbers 1, 2, and 4, and list the matter again after 2 weeks by showing the name of Lanet council for the parties in the published. It is made clear that if the respondent numbers 1, 2, and 4 remain absent despite service of notice, this matter will be taken up for disposal on the basis of materials available on record. Mr. Goswami to come prepared accordingly. Have you told?
Yes,
them?
May I please, your lordship, in this case, my lord, the petitioner approaches before this honorable court for ex gratia benefit, my lord, due to the deceased, due to the death of her husband, my lord. No, on the last occasion also, my lord, they have took time, my lord, for instruction, my lord.
Second lord receipt lords.
Yes, sir.
This is 2023 matter. We'll give them one more time.
Lords.
One more opportunity. Heard Mr. W. Raman, Lanet counsel for the petitioner, also heard Ms. P. Bodoloi, Lanet ST Revenue, and Mr. N. Goswami, Lanet G. Assam, who have prayed for further 4 weeks time to obtain instruction disposing, facilitating disposal of the writ petition. Prayer granted as last chance to seek instruction in the matter, list accordingly.
My lord, obviously.
Please, your lordship, that regarding requisition of vehicle, their main prayer, my lord, that requisition without written order, that's why the problem arises, my lord. For that's main prayer was that, my lord, in case.
We have not received instruction, but it's best for matter.
Bench 4 matter. It
Yes,
appears
ma'am.
that this matter pertains to civil bench 4. Must have registered to verify and list the place before.
Public.
state bench.
Lordship, here we have missed the item. Lordship may take it up next week. We have received the instruction as per I could remember. Next
Mr.
week.
A. Todi, Lanet counsel is present on behalf of the petitioner. Mr. B. Chaudhary, Lanet standing counsel, finance and taxation department also submits that he has received instruction, but had missed the matter in the court list today. As such, Mr. Chaudhary prays for posting this matter again after a week. Prayer allowed, list the case accordingly.
Public.
Item 46.
Lordship, here the BTC has filed an affidavit making a proposal to the PWD that we have to take instruction from the PWD, Lordship. Maybe taken after 10 days, Lordship.
Miss
F Intel.
F. Inter, Lanet counsel for the petitioner is present. Mr. B. Chaudhary, Lanet SCPWD. Prays for 2 weeks further time to obtain instruction on the stand taken by the BTC in their affidavit. In view of the above, this matter stands adjourned for 2 weeks.
I would like to find reply.
Sorry,
I would like to find
yeah.
reply.
In the meantime, the petitioner's counsel may file rejoinder to the affidavit filed by the BTC authorities.
Item 47.
None appears to the petitioner on call, Mr. N. Goswami, Lanet.
Item 47.
Lanet Government Advocate Assam is present. Since the petitioner's counsel is absent, this matter stands adjourned for 2 weeks.
Item 48.
Yes, what is the matter?
If your lordship just give me only 15 minutes so that I can.
15 minutes.
I
What
will
is the
clarify
matter, first
because-
of all?
Because this has tactfully been done by the authorities. The various discrimination, and even if your lordship will also pursue the affidavit file.
There is a problem here. Have they not informed you in the morning?
Yes.
This matter cannot be taken up by this bench.
But just because of the fault of the registrar should,
So we'll have
Yeah,
it tomorrow,
right.
tomorrow before you're there tomorrow.
yes, I'm there tomorrow,
All right, then it will be listed tomorrow. We'll pass
before
it
the
on.
division bench.
Yes,
As a
yes.
fixed item, your lordship.
Yes, yes. Swati Bidan Barua, Learned Counsel for the petitioner is present. Mr. N. Goswami, Learned Government Advocate Assam is present on behalf of the state.
All the respect.
It is pointed out that having regard to the nature of relief sought for in this lead petition, this matter pertains to division bench number 1. In view of the above, we need to verify and list this case tomorrow. In view of the above and considering the urgency expressed by the petitioner's counsel, by the petitioner, you are appearing in person.
In person.
Yes. Swati Bidhan Guru appearing in person. By the petitioner appearing in person, register to list this case again tomorrow. That is, give the date before the appropriate bench.
May I please, Your Lordship? My lord, the matter relates to a very narrow campus, my lord, regarding no confidence motion. My lord, the requisition was issued on 14th. If Your Lordship would consider only 3 dates, it was,
Yes.
my lord, requisition was made on 14/3.
14/3/2023.
14/3/2023. Secretary received the same on 17/3. Secretary placed the matter before the president on 18/3. And my lord, before 15 days could expire on 30th/3, secretary forwarded the matter before the president Anchalik Panchayat. Now I would like to show my lord from the documents over here. If Your Lordship come to the page 17.
So what has happened? Resolution has been passed.
Yes, my lord, what happened? Though it is on 30th/3, within 7 days, the Anchalik has to take the decision. Otherwise, if we take that 15 days, 15 days not into consideration at a moment, within 7 days he has to take, he did not take. So those persons approached this honorable court. This honorable court passed the order in this manner, my lord. This is annexure 4 page, operating part is page 27. And the order was passed on 17/5/2023. It is observed that the pendency of the writ petition shall not be a bar for the respondent authorities to proceed with the matter as regard to convening the special meeting to discuss the motion of no confidence. Taking the advantage of this, the Anchalik Panchayat has called the meeting and took the resolution, my lord.
You have to prefer an appeal against this order.
Which one, my lord?
This order.
No, this appropriate authority could have been the deputy commissioner.
Court has granted the liberty, they have held the meeting.
No. Court said respondent authorities. Anchalik doesn't have the right. Court did not set the Anchalik. That is the whole crux, my lord.
Then we'll hear it. That will be cutting things very fine.
No, but another thing, only this issue. Whether it was before 15 days or after 15 days.
Mr. Abidin, the point is, there is an order of the court dated 17/5/2000.
Yes, I understand.
This order allows them to convene a meeting.
Yes.
This is an observation made by the court
Yes, madam.
on the facts of the case. So that is a court order,
Yes, madam.
and they have followed the court order and held it.
No, that's the thing. I
You
said,
cannot now argue that they could not have done it on that day.
no. I said the respondent Anchalik could not have done it. Could have been done by the deputy commissioner because the next step, the deputy commissioner. 6/4 date ends of the Anchalik Panchayat. On 30th, requisition is sent to the Anchalik Panchayat. 7 days.
So that will be a final, that cannot be done in an admission, or you wait, we'll take it up. This will require a full length hearing. You saying that it cannot be done is not enough. You have to substantiate your argument, because we'll have to see how to interpret a court order. Court order has to be taken on its face value. There is no question of interpretation of court order. When they say that for the respondent authorities to proceed, Anchalik Panchayat is also an authority. So why it would not include the Anchalik Panchayat?
Because
You have
on
to argue.
No,
on that.
what I'm saying, as your lordship is aware of this no confidence motion case, they approached in the month of May, but on 6th April, the time of Anchalik Panchayat was over. Because he has to do it within 7 days or don't do it.
You are right, Mr. Abedin. Let me dictate the order. Court granted the liberty, they held it. You accepted the court order, that's the end of the matter. Otherwise, you have to show how to interpret a court order This order is against your client, you have accepted it.
No, this order was not issued by me,
Alright,
not,
alright.
not by my client. I'm the president. They approached this honorable court.
But you are not a party.
Yes, I was a party,
Then,
but this case has been turned to be infructuous. On the last occasion, the case is closed. When I approached this honorable court, they said their petition has become.
all right. You want to argue today?
My lord, would your lordship be pleased to fix a close?
Whatever, you want to argue today, you can argue. You are free to argue your case. There is no difficulty.
Only thing is, my lord, then could it be on 29th? Hearing date.
I'll leave it to your lordship.
Hmm?
I'll leave it to your lordship.
All right. Mr. Abidin, learned counsel for the petitioner seeks posting of this matter on 29/8/2023 with a request to take up the writ petition for final disposal. The prayer is not opposed by Mr. S. Datta, learned SC, PNRD Department, Assam, as well as Mr.
Appearing for respondent number 826.
What is your name?
KU Ahmed.
Mr. A.U. Ahmed.
KU.
KU Ahmed, learned counsel appearing as per numbers 8 to 16. Ms. S. Burwal and Government Advocate Assam is present on behalf of the state. On the request of Mr. Abedin, this matter is direct posted again on 29/8/2023 as a fixed item. But you please check up these things.
Yes,
As per court's order, I'm record.
the
original
record has
is
been
here.
called.
I know, without seeing the record, I know this is the stand they will take and the court will accept it. You ought to have challenged that order. You have not.
Obliged.
This is with regard to the structural waiver scheme was initiated by the APDCL. my lord. We paid the principal amount, but thereafter they have refused. Well, there's an interim order, my lord, and we have to we have to make some deposits. We have already made, my lord. So affidavit perhaps would be required, madam. So I've received limited instructions. Payment has been received. The primary issue that is involved is, madam, as per their application, the amount that was calculated by them without verifying the same with the APDCL, madam. They applied.
50 lakhs have been paid.
Yes, madam.
So you file affidavit,
Right.
entry model will be
Right.
continued. I heard Mr. M. Datta, learned counsel for the writ petitioner who submits that in terms of the interim order dated 24/7/2023 passed by this court, sum of rupees 50 lakhs have been deposited with the respondents. Mr. B. Chaudhary, learned standing counsel APDCL appearing for the respondents has appeared and confirmed the said stand of the petitioner's counsel. The learned SC APDCL, however, seeks 4 weeks further time to file affidavit. In view of the above, let this matter be listed again for admission after 6 weeks so as to enable the respondents to file affidavit by serving advance copy upon the petitioner's counsel. Interim order passed earlier to continue.
Well, can I pay for a date, madam?
Fix a date after 6 weeks.
Madam.
What is your hurry? You have a interim order?
Well, the other things are there, madam. Either we pay or don't pay, madam. It's getting accumulated.
So what is the date after 6 weeks? This is the matter again on 29th September.
29 September. Deeply obliged. Deeply obliged. My lordship, please.
There is problem here. This is the partnership dispute.
Absolutely, your lordship. This is not in a periphery of or jurisdiction of the excise department.
No direction can be given.
No, the license was cancelled, suspended, sorry, by exercise in view of Rule 300 of the excise rules, which the deputy collector or the district collector has no power or jurisdiction over. Section 30 is the substantive section of the Excise Act 2016. which gives an jurisdiction to the authority concerned to suspend.
Mr. Datta, I have
And
gone
we have
through.
filed, Lordship, just a minute. We have filed in section 9 application before the invoking the jurisdiction of the Arbitration Conciliation Act. And the learned additional district just prohibited the opposite party, that is who raised the disputes, from interfering into our business. So there were, since 9 months, Lordship, our license was suspended. We are, my employees were.
No, you see, the problem is this.
Lost.
It is a partnership at will. Yes or no?
It is a family partnership.
Is it a partnership at will?
Yes.
It is a partnership at will. The moment there is a dispute amongst the partners, the only recourse is dissolution of partnership and rendition of account. You cannot stretch it. The partnership is not in existence today. So no license issued in favor of partnership.
No, so sorry, Your Lordship. I'm just make a respectful submission. They are only disputing that the sharing of the partnership, but they are not issuing any notice under the Partnership Act for dissolution of the partnership. So that is not there. We are already, the subject matter, we have already invoked clause 25 of the partnership clause of the deed. And the arbitration proceeding that has been initiated.
But they are not parties here.
No. The person, no, because of the fact on that score that the district collector not suspended my license. Invoking that is a separate, he has taken a separate hearing. There are two parts of the impugned order. The first part is the partnership. Second part, the district collector invokes rule 300.
How many partners are there now?
There are four partners, 2, 1. Now it's we 75% we have stopped, and 25% that is who has raised the dispute.
They are not parties in this petition.
The Lordship and respectful submission is, if your Lordship have a glance at the impugned order, Lordship will find that the two.
I followed your case.
Lord.
You say that let the partnership dispute go on its own track. Allow us to operate the license. That's your plea. That's what you want, is it not?
Lordship, my respectful submission is that the district collector will suspend my license. And this partnership form is 1989. That is converted the license to a partnership. This is 1926 of 8, 1989. So therefore, your Lordship, that the district collector on the second part invoking the rule 300, Lordship. Since 9 months, our shop was closed.
No, that is
That
bad.
is the whole
That
issue,
is
Your
bad, but.
But who will open the, who will decide this issue of this cancellation of the license? That is the only the district collector. And therefore we are before
This court can only ask him to hear all the partners and pass a fresh order. Beyond that, not possible.
That is not an issue, Lordship. My respectful submission, Your Lordship, kindly bear with me.
At 2, you are to hold up.
Lordship.
But if you are arguing on the law points, I must also remind you that these facts are not brought on record. That there is a partnership. According to you, this doesn't matter, but that is your own perception. That is not binding on the court.
I'm bowed down to this honorable court, Your Lordship. I cannot say so.
See, there is a partnership dispute between the parties. That dispute
can be resolved
today.
That can be resolved, Your Lordship. My respectful submission.
Can be resolved.
Can be resolved.
Who will resolve it?
That is through an arbitration proceeding.
But before that, you should be allowed to run. The license will be operated, but the other side will be allowed to operate it. Are we agreeable to that order?
We are
You will not interfere in the-
we are all participated because we are all partners. We are all participated.
Then why they are not parties in the writ petition? That's what I'm asking you. If you are all together, why only 3 partners have come? You have not been able to answer that. You see, you are invoking a equitable jurisdiction of the High Court.
Lordship.
Correct.
Lordship.
Equitable jurisdiction is to be exercised under 226
Lordship.
to compel the officers to perform their statutory duty. If the officer says, sorry, whatever be the ground, Now there is a partnership dispute. I don't have clarity. Give me a clarity on this. The court will have to pass a direction recognizing either your client's right or the right of all partners in a varied matter.
May I submit one aspect, Your Lordship? That since they absolutely correct the Lordship's observation. There is it's correct that there is a dispute between the partners. And there is a forum for redressal of that issue. But so far the license is concerned, that is the authority of who has invoked the power under Rule 300 and suspend my license.
So why are you saying my? Who are you?
I'm
license
two
doesn't belong
partners,
to
Your
you.
Lordship. We are
You
two
are one
partners.
of the partners. The license was given to the partnership.
Yes.
Why are you saying my?
No. These are two partners.
Hmm.
There are altogether three partners. We are 75%. And we filed the additional affidavit before this honorable court, saying all these facts, Your Lordship. Two partners we are.
So Datta, at least you
Lordship.
should have impleted the other side.
Lordship.
Very
So
difficult.
Lordship is fine.
I'm not.
I'm
inclined-
agree with this. I'm absolutely bow down to this honorable court. Your Lordship says, because finally you have to, Your Lordship, this is our entire scope, there's 22 lakhs of rupees, all the stocks are there. Some of them, like market, like, this whole trouble we have faced. Your
I
Lordship.
am asking you,
Lordship,
why
may-
are you delaying the matter? Why are you delaying the matter?
That I cannot answer. I'm appearing today first, Your Lordship, that
You
that's
means-
absolutely.
You means not you as an individual.
No,
but
Lordship,
your client.
I understand.
Why are you filing a writ petition by keeping some partners at the bay when there is a partnership dispute? When you are asking for a
Lordship may
positive-
then pass an order, if the Lordship on this scope. If the Lordship may pass, we have file a dusty service to be there. Lordship may, my oral submission.
That's the
if you-
submission whom?
Whom the opposite party. We may file an
Opposite party
application.
number?
We may file an application to implement the annual. That is the.
We file. You file an application for implement. Without hearing them, the writ court cannot pass this order.
Lordship. That's I understand. That is a absolutely correct. As a pointed to by this honorable court.
Whatever be their stand, they may oppose, they may agree. But then keeping one side in the dark, how can you pass a positive order when there is a matter pending before this arbitrator? This whatever observation order passed by the court.
I do not, my respectful submission, Your Lordship. I'm only concerned before this honorable court to, so far that second part is concerned. So for the first part is concerned, that we will already involve the proceedings, which is a sub judice now. That so far that part is concerned. I'm only saying, Your Lordship, the second part, because the partners, the other party, they always get the benefits, liabilities, and the assets of the partnership firm is always there. We cannot deprive anybody because the license is of 1953, Your Lordship. For small disputes, we can, what is it is a subject of resolving, Your Lordship. It cannot be said this is unresolved disputes. It will be resolved through a process, and that process we already that we submitted ourselves for that process, Your Lordship. That
Mr.
Lordship
Mr.
can
Datta,
consider.
this is not a legal argument. The argument that you are making is not based on.
The Lordship, one thing, I mean, if your Lordship agree with to hear me on this point. If Lordship finds that the jurisdiction.
I will hear
exercise-
you at two. Come,
Lordship,
hear the matter.
Lordship. Please.
At two. Yes, call to the other two.
May it please your lordship. Lordship, this matters. I have instructions to withdraw, lordship. Lordship, only liberty may be given for approaching.
What is this matter about?
Lordship, there were two matters. One was for
Against the
against
notice issued by the NHIDCL regarding slow progress of work. my lord. And next one is against the retender, my lord. And that has been already annulled. So
retender has been annulled, but the progress of work is still going on. So lordship, this is
So
continuing.
fresh cause of action,
Yes.
same cause of action you
Lordship,
cannot.
Lordship, excuse me.
Miss
A Neog, lordship.
A.
Neog, lordship.
Neog Learned Counsel appearing for the writ petitioners in both these petitions submits that she has instructions from her client to withdraw these writ petitions. and therefore an order be passed permitting the petitioner to withdraw both the writ petitions with liberty to file as and when a fresh file again as and when a fresh cause of action arises
Lordship.
in the matter. Mr. R.K. Talukdar, learned Standing Council, NHI
DCL.
DCL and Ms. K. Pukan.
For CGSC.
Ms. K. Pukan, learned CGC, appearing for respondent number 1, and Mr. R.K. Talukdar, learned so and so for NHI DCL are present and do not have any objection if the prayer made by the petitioner's counsel is allowed. In view of the above, these writ petitions are hereby disposed of on withdrawal by clarifying that the petitioner would be at liberty to file fresh writ petition as and when a fresh cause of action arises. By clarifying, needless to say, petitioner would be at liberty to file.
May it please your lordship, my lord, the judgment, the relevant portion of the judgments that what you can see at page.
Notice has to go.
Notice, please.
Mr. H. Amwa, notice 8 weeks, multiple.
Obler.
Who is appearing? 9 appears passed over for the day.
Please, your lordship. This is regarding non-compliance of the order dated 27
Yes,
to
please, so-
2023.
Multiple, and notice 8 weeks steps.
Because I have filed I am we call for the copy that the Sikan
I don't understood a word of what you said. What are you saying?
I have filed I am to produce the copy of Jamabandi.
Copy of
Jamabandi.
why IA? What is the writ petition about?
The writ petition is there in a subject land. Land was in my proposed land that was land but we have applied for a correction of the land record, but that is not corrected.
All right, you applied for certified copy of Jamabandi.
I applied, my lord.
Lordship,
That is not given. I have mentioned, they are mentioned in the reply. I applied for the same, my lord. I have mentioned petition also, my lord, that is not given.
Yes.
Lordship, the original cheetah copy is with me, your lordship. They have submitted. Thereafter, I have filed an affidavit also, your lordship. And again, your lordship, on previous occasion on 5th of June 2023, this honorable court has issued direction to furnish any land documents if there are any. Lordship, I have received, lordship, in this document, your lordship, the dark numbers 377 and 3.
So you furnish him the copy, that's all.
No, lordship, these the crux of the matter is it's a Sarkari land, your lordship, and he wants correction of.
Crux of the matter is furnish him the copy, not whether the land belongs to X, Y, or Z. You furnish the copy.
So I have received it, your lordship, from the department, your lordship. I'll
Give him
furnish.
a copy.
It's
But
it's
it can't be a
written
certificate.
Sarkari land.
Huh?
It's written Sarkari land.
So what? You give him the copy of the Jamabandi, that's all.
Have it with me, your lordship.
Sarkari land, Jamabandi cannot be given.
No, your lordship, it's not that. I'm just explaining it to you, your lordship.
He has asked for certified copy of some
Have it
Jamabandi.
with me, I'll
Give it
give
to
it to
him.
you. Yes, sir.
Or he can apply it. Why don't the department give it to his certified copy to him?
That I don't know,
I have
your lordship.
rejected.
They have given me on.
Mr. Rashid Lanik Council for the applicant also heard Ms. N. Bordole, Lanik Standing Council, Revenue Department, Assam, and Mr. N. Goswami, Lanik Council appearing, Lanik Government Advocate appearing for the other respondents, full stop. This IA has been filed by the applicant stroke lead petitioner seeking a direction upon the respondent numbers 4 and 5 to produce the Jamabandi book pertaining to land covered by dark number 89 bracket old bracket close 377/379 new of patta number 44 situated at village Bheragaon, Bagbor Revenue Circle, Jonia Moja in the district of Borpeta. Miss Bordole submits that she has received the copy of the
Right
Jamabandi,
now I'm giving.
according to which the land in question is a Sarkari land. However, in view of the request made by the applicant's counsel, Ms. Bordole submits that photocopies of the revenue record will be furnished to the applicant's counsel during the course of the day. If that be so, nothing further survives for adjudication in this IA. The IA stands closed.
Item 48.
Unauthorized.
May I please, your lordship? I filed that interlocutor application for deletion of the name of the NHIDCL lordship.
Why?
Lordship, because the issue involved in the case lordship for construction of flyover at Mission Saril at Dashpur lordship, that has not been constructed by the NHIDCL lordship. So
We have no objection.
Heard Mr. R.K. Talukdar, learned counsel for the applicant, also heard Mr. S. Your S.
Day,
Day,
my lord.
learned counsel appearing for the OP read petitioners, opposite parties stroke read petitioners.
Lordship.
The applicant, namely National Highways Infrastructure Development Corporation Limited, bracket NHIDCL, and its officials have approached this court by filing this IA seeking deletion of their names from the arrow parties in the connected read petition. Mr. Talukdar submits that the subject matter of dispute in the connected read petition pertains to construction of a flyover
yes, lordship.
at Tezpur,
Mission Saril.
Mission Chareli. But the said flyover is being constructed by some other
Yes.
authority, and the NHIDCL or its officials have nothing to do with
Yes,
the
ma'am.
matter. First, according to Mr. Talukdar, his clients have been mistakenly arrayed as parties in the writ petition. Mr. Day submits that he would have no objection if the prayer made in the IA stands allowed. In view of the above, and having regard to the statements made in the IA, the prayer made by the applicants is hereby allowed. The names of the applicants who are impleted as respondent numbers
4, 5, and 6, your lordship.
4, 5, and 6 in the connected read petition shall stand deleted from the array of parties. The read petitioner to file an amended cause title in the read petition by incorporating the above changes, IA stands disposal. You file an amended cause
I
title.
will do that. Much obliged.
Lordship, in this case also I have similar pillar lordship, that issue involved is to be done by the National Highway Authority of India lordship. So NHIDCL is wrongly made party lordship.
Lordship, what happened in this case? I am appealing for resolution number 3, NHAI. The petitioner has claimed the compensation lordship. Her husband has already received the amount. Yes, I have the receipt lordship. Her husband has already received the full compensation for that land she is now staying.
She has not informed her. And the reason is very
Oh,
obvious.
lordship, the wife is very much.
You must catch hold of your client. She has received the compensation.
missed my.
All right, now this is for deletion of name.
My lord,
Yes.
my lord, I missed my file, even then, my lord, he filed a petition for deletion, my lord, I have to take instruction. Just a few days may kindly be granted, my
Lordship.
Heard Mr. R.K. Talukdar, learned counsel appearing for the applicant on the request of Ms. B. Devi, learned counsel for the OP read petitioner. His matter stands adjourned for a week so as to enable her to obtain instruction. Ms. R. Bora, learned standing counsel, NHAI,
NHAI,
and Mr. R.M. Das, learned standing counsel,
Dima Hassan, and she is.
and she is Autonomous Council, along with Ms. K. Fukon, learned CGC are present on behalf of the.
Lordship, may kindly fix on the next Wednesday. In the meantime, I have prepared the affidavit with me. So I'll file it tomorrow.
It'll come within 1
Because,
week.
Lordship, they have already received the compensation even
You
there.
file it, it'll come within 1 week.
Lordship. Due. Receipt of due, huh?
How many more matters? After this, don't come. That too, I'll say.
May it please your lordship. Lordship, this IA is for withdrawal of the name of the petitioners from the instant writ petition. 6 petitioners are there in this.
What is the provision to withdraw from writ petition? There is no such provision. It has to be a joint application filed by all petitioners. You are appearing for whom?
I am for the respondents, madam.
Any
The private
objection?
respondents, my lord. I don't have any objection.
My lord, in this matter, my lord, I come up before this honorable court with 12 number of petitioners, my lord. 6 number of petitioners have filed this IA, my lord. And my lord, neither any NOC has been obtained from me, my lord. Nor, my lord, I have been informed over telephonically, my lord. There is a, my lord, connected case, my lord, writ petition. My learned brother has not also been informed, my lord. We have not been provided with a copy.
You
my lord.
can't do it like this. There is a procedure, huh? You please check it.
And they have, my lord, since 2017, they made some of the applicants, my lord. They made complaints before different authorities, my lord. This is a matter of record.
Then you file objection. Miss
Amen
MN,
Konyak. Amen Konyak.
MN Konyak, Learned Counsel for the applicant. This IA has been filed with a prayer to permit the applicants, that is the 12, how many, how many?
There are 6 respondents, Lord.
6 respondents,
6 petitioners.
6 applicants to withdraw their participation from WPC number 4427 of 2022, wherein they figure in the list of writ petitioners. Mr. M. Das, Learned Counsel for the original writ petitioners, submits that this IA is not maintainable and therefore he be granted 10 days time to file objection. Similarly,
In the analogous matter and the petitioner matter, I have not been served with the copy.
Oh, sir.
in the other matter, Mr. P. Sundi, Learned Counsel for the writ petitioner, submits that no copy of the IA has been served upon him. Mr. G. Chaudhary, Learned Counsel, is present on behalf of
10 and 11.
yes,
R
for
10 and
numbers
11.
10 and 11. Mr. N. Goswami, Learned G. Assam for the state, and Ms. G. Bora for the Health and Family Welfare Department, and as well so and so for respond number 9. On the request of Learned Counsel appearing for the writ petitioners in both these proceedings, this matter stands adjourned for 2 weeks so as to enable them to file objection. In the meantime, copy of the IA is served upon Mr. Sundi so as to enable him to file objection.
Copy has not been given to me. also.
Yeah.
For the Learned Counsel for the writ petitioners. You have to,
Okay.
please check up. Yes.
Wait, Mr. Lordship. There is a office note. And I love my court, my lord, respondent number 4 has been served, my lord. 5, 6, 7 have not been served. But we are praying for allowing us to take justice stationers. Because the postal receipt return saying address improper, my lord, but these are the address which were issued in the certificate that have been issued to them. And the state respondents have not yet filed their affidavit in this case.
So you have to take justice service along with fresh steps, both.
Yes, that will do, my lord. As regard 5, 6, 7. 4, my lord, it has been served, my lord, there is a report. But nobody appears on behalf of.
Where is it mentioned that 4 has been served? All right. Mr. R. Dubey, Learned Counsel for the petitioner, is present. Ms. S. Barua, Learned Government Advocate Assam, has appeared for respond numbers 1, 2, and 3. Perused Lojima Court order dated 05/08/2023, which goes to show that respond number 4 has been served in this case. Full stop. Mr. Dubey submits that since unserved notices have returned in respect to respond numbers 5, 6, and 7, the petitioner be granted due to insufficiency of address and oblique or non-availability of addressee. The petitioner be granted liberty to ascertain the correct address of the said respondents and thereafter take fresh steps for service of notice by registered post with AD. In addition, a prayer has been made for making justice service of notice upon respond numbers 5, 6, and 7. The prayers made by the petitioner's counsel stands allowed. Justice service of notice on respond numbers 5, 6, and 7 be routed through the registry of this court, whereafter an affidavit be brought on record. In the meantime, register to verify if any council has entered appearance for the respondent number 4 and list to matter by reflecting the name of learned counsel for all the parties in the cause.
Direction to them to file a response, but they have not filed.
The official respondents may file affidavit in the meantime, bringing their stand on record.
Your Lordship, we have filed an affidavit with regard to service upon respondent number 5 and 6, that the service has been completed. It has been served upon them. But they have not appeared, Your Lordship, private respondent.
Dusty service.
No, Your Lordship, register post, we were given the liberty to collect the postal receipt, track it, and then give a report that we have done. Affidavit dated 18/7/23, Your Lordship.
That is 5 and 6.
5 and 6, private respondent.
So we'll put it before Lojima to pass an order.
That can also be done, but there is an office note, that is, office note just says that about the delivery. It can be placed here.
Minister V. Senapati Lawrence, counsel for the petitioner is present and have invited the attention of this court to the affidavit dated 18/7/2023 containing the postal report on service of notice upon respondent numbers 5 and 6. Ms. S. Borua, learned CGC, has appeared for respondent number 1 and Mr. R. K. Talukdar.
2, 3 and 4, my lord.
In view of the affidavit, in view of the additional affidavit dated 18/7/2023 filed by the petitioners, this matter be placed before the Lojima court for verification as to whether service of notice upon respondent numbers 5 and 6 can be deemed to be complete in this case. List this case again with appropriate orders from the Lojima.
May we place the impugn order, Your Lordship? Impugn order may be placed. Or otherwise, one thing I may draw the attention of the Supreme Court, Your Lordship, that the partnership deed, because there is a strike in the mind of the court in respect of the dispute of the partners. So that is not in the record. So that we may bring in by an additional affidavit.
Whatever you want, you are at liberty to.
So that's what it is, because Lordship has pointed out that also, that it's a dispute. So therefore, in the partnership deed, there was an agreement between the parties, Your Lordship, that the majority decision will prevail. So, and there is an arbitration clause also, but that has to be, that is not in the records, Your Lordship.
What do you want?
So we matter may be fixed, Your Lordship. Meanwhile, we'll bring the documents before, in the record.
You want adjournment?
That document we like to bring.
Your case
Yes,
is
yes.
that if you give me a good order, take it today, otherwise adjourn it. That's what you want to say.
No.
Then,
Okay, absolutely. Absolutely.
yeah, why are you hesitating?
Not
You
sure.
said the matter to be listed now. I have posted it. Now you can argue. And
So that I'm just rethinking the matter, Your Lordship, after the deliberation.
that's right.
Yes,
So I have pointed out what are the issues.
yes. So
You may be able to convince the court. But if you have doubts yourself, then you decide what you want to
yes,
do.
that will
We
bring
will go
the
by law.
partnership deed we have to bring in.
The court has to go by the law.
Yes,
It's a law.
absolutely correct.
So you make up your mind what you want.
But it's better to bring that partnership deed in the record.
So you are seeking
Yes,
adjournment.
Yes, Lordship.
How long? For how much time?
22nd or 21st of August, Your Lordship, because the matter is also being urgent. We have to dispose it down.
But Mr. Datta, I must tell you, unless the other partners are made parties here, this court don't expect any order.
Yes. Therefore, we
You
Then
can't,
lordship
you
has
can't
a-
have a dispute between partners.
Yes.
Some partners coming and getting a mandamus
Yes. Yes.
upon the authorities to allow them to operate a license.
Therefore, lordship may take a call after we bring it to the, then we decide if lordship is what would be the good, that
When,
is
when do you want to?
on 21st of August, your lordship. Or 22nd. And
On the request of Mr. B. Datta, learned senior counsel appearing for the petitioner, this matter stands adjourned till 22/8/2023, so as to enable him to file an additional affidavit, bringing on record the partnership date relevant for the.
and the
partnership,
latest order and the orders of the lordship in the section
as
9.
well as the orders passed by the learned district judge Tinsukia in the applications filed under section 9 of the Arbitration and Conciliation
Law.
Act 1996. Mr. N. Goswami, learned government advocate Assam, is present on behalf of the official respondent. On the request of Mr. Datta, this matter is directed to be listed again on 22nd.
22nd. Lordship.
22nd of August, 2023.
Highly obliged.
Yes, but please.
Lordship, I understand.
Please also go through, there are number of judgments.
Lordship.
This is a partnership at will, which is
Yes.
evident.
Yes, I am reading that
if there
act
is a-
also
if there is
after
a-
the deliberation.
If there is a dispute within the partners, there are automatic
Section
consequences.
43.
The court, while dictating a judgment, will take note of that.
Yes. Section,
So it is up to you whether you
section
want to.
43.
Hmm.
We'll deliver it the matter.
What is the,
Absolutely.
what is the impact of that? And you are asking a writ of mandamus, which is a equitable relief, relief in equity.
Lordship.
And you are keeping some
The other
partners
partner
out of the. purview
Not
of
to be
this,
hard, yes.
on the ground that majority decision will prevail.
No,
That is an argument. That could be an argument
Lordship.
for some purposes. But that cannot give the petitioner the right to exclude the other partners from a writ proceeding where there is a relief sought based on the partnership arrangement. Therefore, you please examine it.
Absolutely, Lordship is correctly mentioned and we have to deliberate that matter.
You examine it and see
I-
what is to be done.
Highly.
Right.
Wait for your lordship.
My lord, may I give a little background why this writ petition has been filed, my lord?
Hmm.
May I please, your lordship? Lordship, the additional senior counsel, Bijay Talabra is lakes on court number 7, your lordship. First time it was time being, your lordship. Yesterday he has appeared, your lordship. So today he is in the midst of the
Let
Yes,
him
Your Lordship.
submit, we'll see what is the matter.
Your lordship.
Proceed.
Your lordship.
What is the matter about?
My lord, the petitioner number 1 before lordship, my lord, he is a very renowned heart surgeon. And he also is a my lord, transplantation, my lord, thing. Dr. Dhoniram Borua.
Oh, that big heart.
Yes, my lord. Your lordship will remember, my lord, that xenotransplantation was successful. The patient lived for 10 days and thereafter 10 or 11 days. Thereafter, because of infection, he died. And subsequently, your lordship now knows the same transplantation has been done in the USA and he gets a, my lord, Nobel Prize. Anyway, my lord,
There the patients are surviving? No,
no, my lord.
there also patients have died.
There, I'm not very sure, my lord. I think he has also died, but he lived for 3 months or something like that, if as I remember. Now, my lord, what happened? He has got that my lord research institute and hospital in Honapur, my lord. Now, on a particular date, that is my lord, 15/12/2009. What happened, my lord? 6 persons of one family were killed. And 2 of the severed heads were found just near the wall of the his hospital, his my lord research center. And perhaps some local people suspected that the institute or these petitioners may be involved in the murders. Now, what happened immediately after that? First, my lord, the TV channel reached there. Police reached subsequently. And in presence of the police, a large number of crowd entered into the hospital campus And my lord, they have destroyed the hospital, his laboratory. He had some animals, a large number of dogs, they were killed. And this all happened in the presence of the police. And also, my lord, it was live telecast in a particular channel. Before the police arrived, they all started it. The petitioner number 1 was not there in Guwahati at that relevant point of time. So he came to know, and immediately he came and he lost the FIR. Now, my lord, on the basis of the incident there, police itself, my lord, submitted an FIR. But his FIR was not registered, but on the basis of the FIR by another person and by the Sonapur SI, my lord, 2 cases were registered. Now, his grievance basically is that the entire episode was orchestrated by some high-level politician. That is why the police supported them for the destruction of the hospital. And he wants an inquiry into that particular incident that occurred on that day in his hospital, Heart City. It is called Heart City. And that, my lord, he should be adequately compensated. And the investigation should be handed over to the CBI. That these are the main prayers in the writ petition. Now, my lord, there was another writ petition which was connected to this, and when this matter came up on an earlier occasion, there was a submission made that the investigation has been handed over to the CBI. I don't have any record to that. That was an oral submission. On the basis of that, my lord, the other writ petition has been closed. Now, my lord, primary grievance of the petitioner is that since, my lord, there have been materials to show, number 1, that, my lord, there is a high-level political persons are involved. Number 2, in fact, my lord, the investigating officer who was investigating the earlier incident, against him, my lord, a case has been registered by the police saying that, my lord, he has resorted to destruction of evidence. That case is also there, my lord. And so far as the inquiry is concerned, till now, not a single person from neither the petitioner nor any of the employees have been, my lord, interrogated. It was not interrogated by the police. And the last instruction I have that till now there is, my lord, no interrogation. Therefore, my lord.
What has happened in Sonapur PS case number 134 and 135?
My lord, 134 is a case, my lord, which has been the FIR was lodged by one Nirmal Dolui. 134, that is, my lord, under section 302, 201, 120B and 34. And the status is not known, my lord.
It has been charge sheeted, my lord. 134 is charge.
Then, my lord, 135 is on the basis of the FIR by the sub-inspector. Perhaps, my lord, the FIR of the petitioner has also been, my lord, merged with that. That also we are not very sure. And at one stage, they say, my lord, the charge sheet has been filed. But at later in an affidavit, my lord, they say that involvement of third party is being examined. So, my lord, we are really, and the CID case, which has been registered against a police officer, my lord, for causing disappearance of evidence, that is, my lord, CID PS case number 18 of 2012.
Disappearance or destruction of evidence?
My lord, I think they use the word disappearance. It should be destruction, my lord. So, my lord, the position is not very clear till now. At least, my lord, so far as petitioner is concerned, my lord, although there have been quite a number of affidavits filed, but the latest status of all these cases are not known. Therefore, my lord, my prayer would be, my lord, your lordship would direct them to at least, my lord, file a short affidavit saying, giving the status of all this, including the CBI case. And why, my lord, the petitioners have not been interrogated?
Petitioners have not been
interrogated. Their, my lord, house has been, their hospital has been, my lord, ransacked. That will be my prayer. This is, although, my lord, this is a 2009 case, but if your lordship sees the affidavit, they will find that there are many affidavits saying that this investigation, this has been search sheeted, then say, no, we are making further investigation.
And more so, my lord, because very important persons may be involved behind the background. That is the allegation made, and that was, my lord, also circulated in the newspaper. All the documents, my lord, I have placed on record. Let them file a short affidavit, my lord, giving the status
firstly,
where
my-
charge sheet has been filed, what is the status of the CBI inquiry, why the petitioners and nobody from them have been interrogated.
We have filed affidavits in different point of time, my lord, and annexing the status report of the cases. But the last being, my lord, last being 33/2021.
33/2000.
21. That was filed by one Munna Prasad Gupta.
That was the my lord, last
Commissioner.
affidavit.
That
Yes.
that was the last affidavit. That says, my lord, only the last paragraph, that the deponent said that the investigation of Sonapur PS case number 135, not 34, I'm sorry, 135 of 2009 has already been completed, and the charge sheet was filed against the 15 accused person, including one absconder. By Sonapur PS charge sheet number 239 of 2013.
What
That
about
was-
134?
That is, nothing has been said, but at different point of time, my lord, the status reports were submitted before this honorable court.
No, but all right, 135 was registered on the basis of Ezahar loss by an
Police officer.
police officer.
My lord. Against some police officer, that they were also probably involved in the.
Correct, but what about the petitioners? Their place has been ransacked. Goods, article
That
destroyed.
instruction I do not have, but about the protection, they wanted to have some protection. That was given, that was placed before your lordship by way of some affidavit, 2-3 affidavits.
In fact, my lord, initially protection was, my lord, directly given by this honorable court. And my lord, the last position was that, my lord, all were, my lord, taken away except one, my lord, PSO is presently there. There is another petition pending, my lord, asking for more protection.
That is a different matter.
Yes, that's a different.
That.
But my lord, this protection was
Who is
given
the
in this-
petitioner number 2 here?
Petitioner number 2 is my lord, one of the member of the trustee. One of the member of the trust, my lord, which runs the Art City.
So it is still up running, functioning.
Yes, my lord.
The hospital is still functioning.
Yes, my lord.
Is it?
My lord, it's
Operations take place.
My lord, the hospital is running that. I know what is whether operations are, because my lord, there was a break in between because the everything was ransacked, my lord, all the operation theaters and all. But it is running, my lord. That is my instruction. And he has got the research team there. They are working there.
Then Mr. Talukdar, why don't you get us a status report
The latest status report.
pertinent to investigation carried out in connection with
In
this
respect of
case?
134 and 18, CID case number 18 of 2.
And he is saying the informant has not, statement has not been recorded till today.
I'll have to take.
14 years have gone. What is the reason?
My lord, I do not know, because everything was before the CID. And
No,
I'll have to
CID is investigating this case,
The
my lord,
police-
against the police officer.
and against the police.
CID PS case number. My lord, 18 of 2012. That is against, my lord, some officer for causing, my lord, destruction of
So
evidence.
Mr. Chaudhary is basically interested to know about PS case 134.
Yes, my lord.
134. 134.
And where is the Ajahar in that? Is it a part of the record?
Yes, my lord. It's a part of the record. I think, my lord, it's annexure 5. Document.
Annexure?
My lord, annexure 3 at page 27.
Short FIR, my lord.
Mr. M.K. Chaudhary, learned senior counsel appearing for the writ petitioners in this, in WPC number 5897 of 2009, has pointed out that based on the Ejahar dated 15/12/2009, lodged by the petitioner number 1, reporting large-scale damage and destruction of properties belonging to the petitioner, as well as attempt to commit murder by miscreants. Sonapur PS case number 134/2009 was registered by the police under sections. Can you say the sections?
Yes, my lord. 134 is 134 under section 302,
302,
201, 120B
201, 120B
and 34.
and 34. Add one more thing, destruction of properties, loss of human life, and
Not loss of human life, my lord.
302 on what?
Oh,
basis?
yes, my lord. Those persons who were killed.
Loss of
Right.
human life,
I'm sorry.
as well as attempt to commit murder. So and so is lodged, so and so it was registered. However, the learned senior counsel submits that till today, not to speak of conducting proper inquiry in the police case, even the statement of the informant has not been recorded by the police. Mr. Vijay Talukdar, learned senior counsel appearing for the state, submits that insofar as Sonapur PS case number 135/2009 and CID PS case number 18 of 2012 is concerned, charge sheet have already been.
No.
Then
Oh, yes,
charge sheet
130.
have already been submitted. Charge
Right.
sheet has already been submitted.
Right.
However, the learned government council prays for 4 weeks' time to obtain a status report as regards the progress made in the investigation conducted in connection with Sonapur PS case number 134/2009.
And
On
also the other one, my lord.
Huh?
Also that CID police case.
On the request of Mr. Talukdar, 4 weeks' time is granted to obtain updated status report pertaining to the progress made in investigation in Sonapur PS case number 134/2009. The learned state council to also appraise this court the status of the proceedings in Sonapur PS case number 135/2009 and CID PS case number 18 of 2012.
Right.
A copy of this order will be furnished to Mr. Talukdar during the course of the day. Call up these matters for hearing again after 4 weeks.
Right.
Thank you. Bless.
List these matters again after 4 weeks. Before the appropriate bench.
Eight and nine. 10 and 11. 12. 15. 16, 17, 18 and 19. 20.
Sorry for the inconvenience, Lordship. Part 1 list, item number 45, I have listed, it has come up for the first time. Can it be taken up?